No. Okay.
Happy New Year to all of you. And your friends who are not there, to them also.
Thank you, your lordship.
Thank you. Yes,
For listening.
listing. Give it to the court master, please.
Chip, with regards to item number 7 and 8 of the daily list, Chip, we have taken consent from the other side. Chip, the counsel for the petitioner is out of station.
Okay.
Chip,
The-
matter may be adjourned for the meeting.
with consent of the other side, the counsel for the petitioner, public appellant, prays for adjournment. Here is allowed. List on. When do you want?
My lord, any day in the next week.
Next week. So I will give. Okay. We'll give a date. The court master will give a date.
24.
Lordship, I beg to mention item number 12, Lordship. Lordship, kindly matter be adjourned for 1 week, Lordship. Item number 12, daily list.
12.
Yes, Lordship.
Please wait for some time in this matter. Please wait for some time. I'll consider a prayer when the matter reaches. Yes.
Lordship, with the consent of the other side, I beg to mention item number 9, my lord, and for the respondent.
You've taken consent? Okay, with consent of the other side. Mr. N. Chaudhary, counsel for the respondent prays for adjournment. Prayer is allowed. List on. When?
30th this month? Possible?
13th is a Saturday.
My lord, 30th.
30. You're taking a long adjournment? Make it 29th. 29th January. Okay.
In item number 19, I have filed one affidavit. I may be allowed to cover it.
Make pleasure, Lordship. Lordship, I beg to mention item 4, Lordship. My senior is out of school. Stand with the matter may be taken up in the next week.
Item 4. Okay. List after a week as prayed for by the counsel for the petitioner.
Lordship, I have mentioned for Passover and my item number is 9.
9. Somebody has taken an adjournment.
29 on the
29.
January.
Okay. Yes, sir.
Who is concerned? Item number 2, top of the hearing. I'm there to argue. The only thing in the second half, I have a visitation time in judgment.
Okay.
So second half may not be good.
We'll take it up now. After this item 1.
The first half may not.
Yes, yes.
Top of the list, item 1.
The whole pending matter, minor. The substitution was supposed to be filed, minor. The learned counsel does immediate me formally, minor. I'm so ready for to file, but one of the managing person is in Bangalore. He's come already. Tomorrow maybe I'll be filing it, minor. 2 and 4 died.
Mr. A.M. Mazumdar.
Take it out.
A.K. Talukdar, I'm sorry. Learned counsel for the appellant submits that he needs a day's time to file substitution application. Praise for adjournment to file substitution application. Prayer for adjournment is allowed. List
Take very fixed.
along with the substitution application in respect of respondent numbers 2 and 4.
4.
Okay.
Date and the delivery.
It will age ago. After substitution application comes.
Top of the list, item 2.
My lord had the matter earlier. Procedures, my lord had read some notes also. Probably.
Yes. Your last reading, cross of PW1.
My lord,
Just a moment. You are the defendant appellant. You claim to be the permissive occupier.
they say that, that in their case that they allowed me
Huh.
to possess it, my lord, since nobody was there. My lord, they said that you will take care of the land. Later on, my lord, we requested that allow us to make some construction. So they permitted us. That is the case.
Yes.
Additional issue was framed, my lord, by the appellate court, and the matter was remanded. Basic issue is, my lord, the right title and interest based on exhibit
Yes.
1.
And exhibit 1 held it, you say that its signatures are not proved.
Signatures are not proof, my lord, and our case is that, my lord, the person who sold the land, he does not have the right to sell the land. So lordship kindly stand to the written statement.
You are saying that because you are also claiming that since the plaintiff did not have a right, did not have possession, only because of that. Just because he did not have possession and therefore sale could not, right to sell was not there.
That was not. And my lord, the earlier date of 1978, because one of the basic challenge in my lord, in our case, your
The Kaifuddin and Lufur, their names were mutated on the strength of sale deed dated 11/4/78.
no, my lord, Dukpur, my lord, Dukpur, my lord, name was, my lord, mutated on the Chicha mutation. Your lordship will kindly also the entry, my lord, that there is nothing, it was based on sale. But so far, Kaifuddullah is concerned, my lord, he, that document, and it will come into the document volume page 50. I have given.
I think you had made a compilation also.
Yes, the comparison I have used. Not both mirror of documentary evidence and mirror oral evidence.
You are referring to the documents. Which page you want me to refer?
15. Exhibit 2. Jamabandi. I am referring to page 15, my lord.
Yes. This is a mutation order.
Oh, that's yes. That's what I know. Your Lordship will find there, চক্র বিষয়ের ইমান নম্বর হুকুম মতে বাট্টার ইমান নম্বর ডাগত এক বিঘা 3 লতা ইমান লতা মাটির মধ্যে এক কথা
This is exhibit now, exhibit.
exhibit 2 madam. Exhibit 2 starts with in the document.
Page 10.
No, it starts with page 6 madam. It's the comparison.
Jamabandi.
Yeah.
Yeah, please read it again, Mr. Agarwal. Please read it again.
I'm reading them.
চিঠা চক্র বিষয়
চক্র বিষয়ার
14-2
2-3-91 তারিখত হুকুম মতে বট্টার 177 নম্বর আগত 1 বিঘা 3 কঠা 9 লতা মাটি মধ্যে 1 কঠা 14 লতা মাটি খরিদ্দার সূত্রে 7 নম্বর স্থলত 24 নম্বর নামজারি ভুক্ত করা হয় 24 নম্বর is Kaifutullah. The person who sold it to Mr. Lutfur Rahman. If your lordship looks into the at page 8 million.
Just a moment, just a moment.
Page 9.
The last entry. 2-3-91.
Yes.
So this number, name 24 is Kaifatullah.
Case of the plaintiff, that may not Kaifutullah sold it. The land in 1978. Sorry, Kaifutullah purchased the land in 1978 and then he sold in 1990. Hold on মানে কি?
Sold on
Sold on 29/1/1990.
but then something is wrong. The Namjari is on 2/3/1991. So sale is made earlier than the Namjari.
A sale is made in 1990. Exhibit 1 is the deed.
This 29/190 is exhibit 1. Yes.
So in exhibit 1, the reference is made of a deed of 1978. 11/4/1978, ডিমান্ড তারিখে 18/11 নম্বৰ ৰেজিষ্টাৰ দলিল খৰিদ কৰি লোৱা নিজ স্বত্ব অংশ দখল ইতি পূৰ্বে বিক্ৰী
What was the date of 1978 deed?
that is 11/4/1978.
Okay. Please come again. This sale deed of 29/1/1990. This is executed in whose favor? Your favor?
Executed in favor of
In favor of the respondent.
And by virtue of that, they are claiming that they have right.
Because some part of the memory has faded away.
Hello?
Some part of the memory has faded away. That's why I'm asking.
But it took, I think 3 months already is over, to receive the matter. In fact, yesterday I was finding it difficult to prepare. I thought that I will take an somehow I could prepare in the night. Little bit. Now, the Namjari was done on 2/3/1991, first in favor of Kaifuddin or Kaifatullah, whatever it may be, and then in favor of Lutful on the basis of the sale that is there. Now, my lord, I have already made submission that my lord PW1 gave evidence. He nowhere said
Yes.
my lord, the signature of Kaifatullah or Kaifuddin was not proven.
even the witnesses who claims to be the witness to the sale deed, they also say that my signature is there, but they have not proved the same. I'll come to Miller PW. Two now. Below the earlier occasion, I have made an submission below that total length, my lord, in the patta and total name, my lord, the Namjari has been done, my lord. It is more than the, my lord, then in patta. Probably my lord has taken note of that.
No, in the sale deed, it's a land measuring 1 kata 14 lecha.
My lord.
In
One
the
kata
sale
14
deed,
lecha.
1 kata 14 lecha, but in Jamabandi it says that the land is 1 biga 1 kata 11 lecha.
Ah.
And in sale deed it is written 1 biga 3 kata 9 lecha. So there is a shortfall you are saying of 1 kata 18 lechas.
So 1 kata 18 lecha, my lord, I have found. So that there is a separate patta has been, my lord, made.
Separate patta was made.
That's what it's my duty to point out to my.
Okay, okay.
Probably for that, my lord, it is showing it to me. 1 biga 1 kata 18 lecha, I do not know, my lord. But in the same, my lord, Jamabandi. I have put right people on. So your lordship kindly see, the 1 biga 1 kata 18 lecha. Total and so on. Now,
Yes.
so lordship kindly turn to page 2, my lord. 1, 2, 3, 4, 5, 6, 7th, my lord, column.
Yes.
1 kata 18 lecha. My lord got it, my lord.
Yes.
While order dated it na out of the total land measuring 1 biga 3 kata 9 lecha, the land measuring 1 kata 18 lecha was notated in the name of Boliram Bora on the basis of purchase in place of Samju land. In this connection, a new dag number itna measuring 1 kata 18 lecha was carved out of the total land measuring 1 biga 3 kata 9 lecha, while order dated itna and separate patta being patta number 278 was issued. That probably in region. Why it has come to be 1 biga 1 kata 11 lecha. Manoj, I have made it.
Just a moment, your last submission I did not record. You said that the PWs did not,
PW1 and PW2, PW3.
they did not prove the signatures.
Huh?
They did not prove the signatures of
Nobody proved the
Kaifatullah.
signature. So one of the PW3 claims that he was a witness to the.
But Mr. Ahmed, please tell us, let us say X is the owner of the land. Yes, his predecessor had purchased that land. He has a sale deed in his occupation, in his possession. Now, is it required that for a deed which is otherwise 30 years old, or a deed where the parties cannot be traced. Unless you prove the signature, the cell deed is said not to be proved. Because here there is no challenge to that deed, if I remember it correctly. The cell deed is not claimed to be void. So in the absence of that query, that issue of the cell deed being void, is it necessary to prove the signature and then say that?
He say, but our case is that may not that, to Lordship kindly look at the written statement. Our whole case is. It may just take a minute. In para 7, we have stated. So it is particularly denied that Capitula had absolute and exclusive right to alienate the suit land. Para 7, page 15 of the memo of appeal.
You see here, in this paragraph,
Yeah.
you see that it is particularly denied that the Kefetullah had absolute and exclusive right.
That is it. To alienate the suit land.
So it is only what you call restrictive, meaning he did not have a right to sell the entire land. That means right is there. That is an admitted fact.
That's true. Lordship, in this sense. But
So his signature is not in dispute. Even if they don't prove the signature, it doesn't have much dent in that.
and then my lord, in para 8, submitted that Capitulun had no authority right to sell the suit land by registered sale deed number so and so. It is particularly denied that 24 delivered. Yes, not. Then
Unless fraud is alleged.
the fraud is eligible. Your lordship will find.
No, fraud means he will say that it is fraudulent sale. It doesn't say fraudulent, fraud means impersonation. So that signature is required to be proved.
Achha, in that sense, my lord.
Because I'll show you something. Right. Signature. It says a mark of a person. So, for example, the signature which I put in the order sheet is different from the signature which I put in my bank account. So, merely because there is a
So that,
mismatch of the signature, it can't show that there is a fraud. Only that limited.
not.
Mhm.
That can't. No, my lord, very signature my signature, my lord, I'm signing here and I'm signing there may vary.
Huh.
That is not the case here.
Oh.
That is not the case. Lordship is rightly pointing out that, my lord, that may vary. May vary.
Only that purpose, no, nothing more.
Not that, my lord, it cannot vary.
Huh.
Even in the bank also, my lord, the signature vary. Nowadays, when I put my signature myself, my lord, I find that my signature is varying, but since they are,
Holidays.
they know it, they don't.
During these holidays, I had to give a check to someone. I had to send person in the bank and then ask them not to dishonor because of mismatch.
Normally, nowadays, I try to be, my lord, transfer the money by, my lord, online transactions.
I had to give a check. It
So-
was a mandatory requirement. So therefore, I had to tell bank people not to dishonor because I was putting my signature after a long time.
Same problem for everybody. I'm mostly digitally, my lord, I am transferring.
No, it's okay, but that's beside the point. But that's the only point. So he had no authority. That is sum and substance.
Some in substance, yes, my lord. Yeah. Problem here, actually.
Yes.
And so far the entry is concerned also, we said that, that has been surreptitiously, the entry has been made. Now, that fact has been admitted by PW1, that no notice, because 16 pattadas were there. No notice of the mutation was given to anybody.
It is PW.
PW1. Another important aspect. May I just pinpoint one aspect of the matter, how far it will be relevant. My lord, the whole case of the 24 that in 1990 he purchased. Now, his house was 1 kilometer away from the, my lord, disputed land. Now, Manikalli was in some case he is saying, my lord, on the, my lord, in the plan it is there, it is on the south. In the schedule also it was in the south, but later on, my lord, an amended plan was filed, where only the, my lord, schedule has been amended and it has been made that it was in the north. But still, my lord, in the entire body of the plan, it remains in the south. The identity of the land is, my lord, not clear. This is number one. Number two, his entire case is that, my lord, that he was, since he was residing 1 kilometer, he asked him to look after Manikali. Manikali means, my lord, the defendant's father, to look after the land. And then he was, you know, on being asked, you know, he was permitted to construct some.
That part you have stated earlier, you said that PW1 admitted that it is true that he did not ask Manik Ali to take care of his land.
That may not, in cross-examination that is there.
Yes.
And may not, Manik Ali, PW1's evidence is that he, the school where he was working is just opposite to the disputed.
Pardon, please come again.
Manik, the PW1's evidence in cross-examination, you know, that the land, disputed land is just opposite to the, you know, the school where he was working.
Okay.
And you know, it is not disputed that, you know, I am one of the pattadar. The defendants are one of the pattadar. In respect of the land, you know, in, you know, the patta number 118. You know.
You are saying that in the pleadings and in the schedule, the land of Manik Ali was to the north.
But it is scheduled, in the original schedule, it was shown in the south.
South, okay. And otherwise in the plaint it is south.
When it remains south.
But in schedule they have amended and brought it north.
They said that the
North.
schedule was altered.
Okay.
One of the question was also put to him that may not whether he, from whom type of thing.
Yes, please continue.
So he said that those documents he has not put. From whom the typhoid purchase, তিনি সে তার কাগজপত্র আদালত জমা দিয়া না ইমান তারিখ সনদ কাপড় উল্কা কাইফুদ্দিনের মাটিটুক বিক্রি করার অধিকার আসিল না না জানো কাইফাটোর মাটি বিক্রি করার সত্য আসিল না মই না জানো
But Mr. Agarwal, it will be a difficult task to appreciate that part of your submission in light of interpretation clause section 3 in TP Act regarding notice. Because if there is a sale deed, it constitutes a public notice to those who are interested in the land. Yeah, you're having that TP Act. You're having the TP Act. Yeah.
TPA.
Section 3 interpretation clause. No, I have it.
A person said to have notice of a fact when he actually knows the fact or when, but for willful absence. My lord is referring to this one. In this act, unless the something repugnant subject movable property does not include standing timber, this is not instrument mentioned so and so and so.
Only that part, that notice, only that part, it has a paragraph also. You see third line, explanation one, or share or interest in the property shall have notice.
My lord.
Explanation one, where any transaction relating to
When any
immovable property.
transaction relating to immovable property is required by law to be and has been effected by registered instrument, any person acquiring such property or part of or share or interest in such property shall be deemed to have notice to have notice of such instrument as from the date of registration or where the property is not at all situated in one sub-district or where registered instrument has been registered under ISNA from the earliest date on which any memorandum of such registered instrument is filed by any sub-registrar within whose sub-district any part of the property which is being acquired or of the property wherein share of interest is being acquired is situated.
So this is this is a notice to the person acquiring the property.
People kindly see here it says any person acquiring such property.
Acquiring property.
I'm not the person who acquired. Or any part, or share or interest in such property shall be deemed to have notice of such instrument as from the date of registration.
Yes.
And if it is in some other district, my lord, once the memorandum is filed in the district where the part of the property is there, no, it will be the notice from that.
Yes. So you say that this will not cover you.
My humble submission, it will not cover. Subject to your lordship's interpretation. Explanation two also. Any person acquiring any immovable property or any share or interest in any such property shall be deemed to have notice of the title, if any, of any person who is for the time being in actual possession thereof.
That is a notice
That is a notice to the person.
to the respondent here. Okay.
In this case, you know, that procedure is to that extent one. He said that no, I do not.
Okay. You are referring to PW2.
I am referring to PW1 Miller first. Lord, your lordship will kindly see in page 7, page 9, last 4 lines.
কারপরা
No, it's the, senior পড়া উল্লেখ আছে কাৰপাত মিছল আছে তেওঁ কাৰ পৰা মই কিনা মাটিটো কিনিছিল তাৰ কাগজ পত্ৰ আদালত জমা দিয়া নাই 1990 চনত কাৰপাত পুৰুষ কাৰফুজিৰ মাটিটো বিক্ৰী কৰাৰ অধিকাৰ আছিল নে নাই মনত নাযায় কাৰপাতৰ মাটি বিক্ৰী কৰাৰ স্বত্ব আছিল নে নাই মনে নাযায়
Yes.
Explanation C refers to minute of agent.
Second is agent.
Expression C refers to minute agent. If the agent had the notice minute, I will have it. That is minute no minute. I will referring to PW2. He was the lot mandal, you know. But not at the relevant point of time when the Lord died. এই বছর আমার চক্র বিষয় আদালত সমন পায় মোক 13 মিনিট এই বছর সাক্ষী দিবলৈ প্ৰেৰণ কৰিছে মোক মণ্ডল হিচাপে কাম কৰা 16 বছৰ হ'ল মই চৰাইবাৰী মৌজাৰ 5 নম্বৰ লটত কাম কৰা 6 বছৰ হৈছে so in this particular lot
Just a minute. Yes.
এই বছৰ আমাৰ চক্ৰ বিষয় আদালতত সমন পাই মোক এই বছৰ সাক্ষী দিবলৈ প্ৰেৰণ কৰিছে মোৰ মণ্ডল হিচাপে কাম কৰা 16 বছৰ হ'ল মই চৰাইবাৰী মৌজাৰ 5 নম্বৰ লটত কাম কৰা 6 বছৰ হৈছে গোহাইগাঁও মতে অন্তৰ্ভুক্ত বাৰী বা আমি ফিল্ডত গৈ কি হৈছে চাই আমি অফিচত ৰিপৰ্ট কৰিব লাগে মই আজি আদালতত 1976 চনৰ জমাবন্দী বহীখন লৈ আহিছো এইখনত আজিলৈকে কাম কৰি থকা হৈছে এইখন আমাৰ অফিচৰ মেইনটেইন হয় নট ৰেলিভেন্ট ইয়াত 7টা দাগ আছে মই কেইটা হৈছে 177 170 we are concerned with 174 উক্ত পট্টাৰ ক্ৰমিক 55তম লুৎফুৰৰ ৰহমানৰ পিতা
You are concerned with 174.
74 we are not concerned with the other
Okay.
पट्टा नंबर 118 डाक नंबर 170 লুৎফুর রহমান পিতা জামিলুদ্দিনের নাম আছে লুৎফুর রহমানের নামজারি হয় 2391 চনত 1 কঠা 14 মাটি আৰু ডাক নম্বৰটো 177 দাগ এই 177 দাগত মুঠত 1 বিঘা 3 কঠা 9 মাটিৰ ভিতৰত 1 কঠা 14 মাটিত নামজাৰি হৈছে খৰিজা সূত্ৰে এই মাটিত আমাৰ নথিপত্ৰতে এই 24 নামখন কেৰফাতুল্লাহ পিতা মহিউদ্দিনৰ পৰা কিনা মাটি এইটো ঠিকঠাক নামজারি সূত্রে হওয়া sale deed was claim was on the basis of purchase but there is no reference of any sale deed and all এইটো ঠিকঠাক নামজারি সূত্রে হওয়া ঠিকা নামজারি দখল চাই নামজারি করা হয় চিঠা বহিত এইটো উল্লেখ আছে যে কেৰফাতুল্লাহ পিতা সয়ঞ্চ লুৎফুৰ নাম লিখা আছে এই মাটিটো মই চিনি পাওঁ যোৱা 6 বছৰ ধৰি মাটিটোত হাইজুদ্দিনৰ দখলত আছে he is in this plot from last 6 years and he has seen that I am in the position of the land in question এই দখলত মই মোৰ অঞ্চলত চাকৰি কালত দেখিছো মই লটত মোৰ 6 বছৰ ধৰি চাকৰি কৰি আছো উঠা বহিত হাইজুদ্দিনৰ নাম উল্লেখ নাই কিন্তু তেওঁৰ বাপেকৰ নাম মানিক আলী আছে কিন্তু মাটিৰ পৰিমাণ কথা উল্লেখ নাই 177 দাগত পদকক 2 হৈছে জমাবন্দী স্বাক্ষৰিত কপি গোহাইগাঁও চৰাইবাৰী মৌজা ইমান নম্বৰ পট্টা the clause is little bit important মই যোৰহাট পশ্চিম চক্ৰ কাৰ্যনিৰ্বাহ কৰা মণ্ডল হিচাপে 6 বছৰ হৈছে এই বছৰীয়া মাটি মোৰ প্লটত পৰে মই বছৰীয়া মাটিৰ দখল সমঝাই দিবলৈ যোৱা নাছিলো 77 নম্বৰ দাগৰ মাটিত মানিক আলীৰ নাম আছে এই দাগৰ মাটিত বিভিন্ন গৰাকীৰ মাটিৰ চাৰিসীমা চিঠা বা জবানবন্দীত উল্লেখ নাই এই দাগত মাটিৰ বটোৱাৰা হোৱা নাই 118 নম্বৰ পাট্টাখন বটোৱাৰা হোৱা নাই বছৰ লগা মাটিত লুৎফুৰ নামত নামজাৰি হয় ইমান চনত জেৰাপটৰ নামত ইমান চনতে নামজাৰি হৈছিল জেৰাপটৰ নামত উক্ত মাটি 11/4 চনত ইমান নম্বৰ এছটি দল মতে খৰিজা সূত্ৰে খৰিজা দেখুওৱা হৈছে চিঠা বহীত এই কথা 2/3/91 তাৰিখত লিখা হৈছে এই মন্তব্যত মণ্ডলৰো সহি আছে 1991 চনত মাৰ্চ মাহত 3 তাৰিখে মই মণ্ডল হিচাপে উপস্থিত আছিলো।
নাছিলো।
নাছিলো নাছিলো আৰু চহীটো মোৰ নহয়। লুৎফুৰ নাম হোৱা নামজাৰি আৰু কাইফাতৰ নামত হোৱা নামজাৰি বৈধ নে অবৈধ মই ক'ব নোৱাৰিম। নথিত মতে নামজাৰি কৰাত নামজাৰি দৰখাস্ত দিয়া নাছিল। যেতিয়া দৰখাস্ত নিদিয়ে তেতিয়া বিক্ৰী দলিল মণ্ডলক দিয়ে। মণ্ডলে SDC পঠুৱাই পাছ কৰোৱাই নামজাৰি কৰে। Theta mutation is mainly done. Theta mutation is done on the basis of the position. The land. But when somebody purchases the land, then he has to file an application. Notice has to be issued on the application. The other pattas and they have any objection, and then ultimately, no objection is received, then the namjari. In this case, that process has not been adopted. He said that it was theta mutation work on the basis of the position. Then Abidul Rahman PW3. He was one of the witness.
Abidul Rahman.
Abidul Rahman was one of the witness to the exhibit 1, cell deed. And he also probably identified that Saifuddin.
But something is wrong. In page 113,
What?
page 113 is PW2. So page 13, 13, it is PW2. That is that mandal. Page 17,
PW2.
page 17 is also PW2.
It is a copy, not been kindly whether there may be some corrections. Copy was have to ask.
Oh, acha, okay, okay,
Maybe may not in the original, it may not be.
okay. But in the cross, it is PW3. Okay. Yes,
By
yes.
the time this man was examined first,
Ha, ha.
then he was
Understand.
cross-examined, so may not.
I understand. I understand.
Paragraph 2, forwards only, relevant, paragraph 2 and 3. 4. গছৰ মাটি চিনি পাওঁ বৰ্তমান উপৰোক্ত বিবাদীগণৰ দখলত আছে। উক্ত মাটি লুৎফুৰ ৰহমানে মাটি কিনা মাটি। মাটিৰ চাৰিসীমা পূব চয়ন্ত মিলিটাৰী কম্পাউণ্ড আছে, পশ্চিমে চয়ন্ত, উত্তৰে মানিকালি মাটি আছে, ঘৰ আছে, দক্ষিণে পথাৰ আৰু কুতুবুদ্দিন মাটি। Then গছৰ লগা মাটি পূৰ্বতে আমাৰ অঞ্চলত মহম্মদ কাইফুতুল্লাহ আহমদ দখলৰ মাটি আছিল। উক্ত কাইফাতুল্লাহ মোৰ জনা মতে আৰু দেখা মতে যোৱা 1990 চনৰ জানুৱাৰী মাহত উক্ত মাটি প্ৰায় 1 কঠা 14 মাটি বাদী মহম্মদ লুৎফুৰ ৰহমানক বিক্ৰী কৰি মাটি দখল সমঝাই দিছিলে। দখল দিয়াৰ সময়ত ময়ো অন্যান্য ওচৰৰ মানুহৰ লগত তাত আছিলো। বাদীয়ে কিনি লোৱা মাটিৰ উত্তৰে মানিকালিৰ ঘৰ মাটি বৰ্তমান বিবাদীগণৰ তাত আছে। লুৎফুৰ ৰহমান কিনি দখল কৰা মাটি খালী মাটি আছিল। মাটি দেখুৱাব দখল লোৱাৰ পিছত বাদীয়ে মাটিৰ চাৰিসীমাত বাঁহৰ বেৰি দিছিলে। মাটি কিনাৰ পিছত মাটি খালি পৰি আছিলে। কিন্তু যোৱা 1999 চনৰ জানুৱাৰী মাহত দেখা গ'ল যে উক্ত মানিকালিয়ে গছৰ উক্ত মাটিৰ ওপৰত 2টা কেঁচা চালি বনাই আৰু মৰমৰা ব্যৱসায় কৰি আছে। যিহেতুকে বাদী মোৰ ওচৰত বসবাস কৰি থকা মানুহ তেতিয়া উক্ত কথাটো বাদীয়ে মধ্যত বাদীয়ে কয় যে তেওঁ বিবাদীগণৰ দেউতা মানিকালি উক্ত মাটিৰ ওচৰত অস্থায়ীভাৱে থাকি দুইটা কেঁচা চালি বনোৱা ব্যৱসায় কৰিবলৈ অনুমতি দিছিলে। যিহেতুকে উক্ত মানিকালি তেওঁৰ বন্ধু আছিল। মই সঞ্চিত তেওঁ কোৱা মতে মানিকালিয়ে প্ৰতিশ্ৰুতি দিছিল যে মাটিৰ অনুপস্থিত চোৱা চিতা কৰিব আৰু বাদী যেতিয়া গছৰ উক্ত মাটিৰ দৰকাৰ হ'ব তেওঁ মানিকালিয়ে অস্থায়ী কেঁচা চালিবিলাকে ভাঙি পেলাই লৈ মাটি খালী কৰি দিব। Basically, it supported the one of cross examination I'm done. মোৰ নাম page 20. মোৰ নাম আবিদুৰ ৰহমান। মোৰ বেলেগ নাম নাই। গছৰীয়া মাটি মোৰ ঘৰৰ পৰা 1 কিলোমিটাৰ কম দূৰত্বত অৱস্থিত। 177 নম্বৰ গছৰীয়া দাগত আন মাটি আছে। সেইখিনি কাৰ নাজানো। সাইফাতুল্লাহ 1990 চনৰ পিছত মৃত্যু হৈছে, কিন্তু সঠিক চনৰ ক'ব নোৱাৰি। তেওঁ ল'ৰা নাছিল। এজনী ছোৱালী আছিল, বিয়া দিলে। মাটি দখল সমঝাই দিওঁতে মই আছিলো আৰু লগত আন মানুহজন আছিল। তেওঁলোকৰ নাম মনত নাই। গছৰীয়া মাটিৰ পূবে যোগৰাম আৰু কেম্পলৈ যোৱা পথ, দক্ষিণে পথাৰ আৰু কুতুবুদের মাটি। গছৰীয়া মাটি যদি সীমাৰ জেওৰা নাথাকে তেতিয়াহ'লে গছৰীয়া মাটি আৰু বিবাদীয়া মাটি সীমা ধৰিব নোৱাৰি। পাৰি নে নোৱাৰি মই ক'ব নোৱাৰিম। এইটো সত্য নহয়, বাদীয়ে দখল লৈ কোনো সীমাত জেওৰা দিয়া নাছিল। বাদীয়ে দখল লওঁতে ঘৰ নাছিল, মাটিটো খালী আছিল, খালী মাটি আছিল। এইটো সত্য নহয় যে দখল সমঝাই দিওঁতে মই নাছিলো। এইটো সত্য নহয়। এইটো সত্য নহয় যে বিবাদীয়ে গছৰীয়া মাটিত ঘৰ বনাই কি চৰ্তত আছে সেই সোধাত প্ৰয়োজনীয় বোধ কৰা নাছিল। সত্য নহয়। He has not
PW3,
stated anything about the let me just check and confirm.
he's, in his cross also he is consistent.
Huh?
In his cross also he is
He
consistent.
I'm not saying. But my lord, so far as the cell deed is concerned, the lordship will find.
No, CLD doesn't say anything.
Huh?
CLD doesn't say anything.
And he is the person, my lord, he identified the Saifuddin, and he is the person, he was witness number 1. He did not say anything. So far, cross examination is concerned, my lord, he is concerned. Now, PW4, he was examined after the matter was remanded back. He is Ataur Rahman. He is another witness to the. He claims to be.
Does it say? He does not say about that.
Lord?
This PW3 does not say that he was a witness to the execution.
No, he has not said anything. He has simply said about the Lord, Dakhal Samjhai di.
He does not say about execution. He was a witness. He doesn't say so.
Lordship kindly look into. Lord, the cell deed. Exhibit 1. Page 3. সাক্ষী 1 নম্বর আবিদুর রহমান, number 2 is Ataur Rahman.
There may be somebody else we don't know because
No,
he does not, he does not
doesn't
say,
anything.
he does not say anything.
He does not say. That's true. Then Ataur Rahman,
We leave it to Mr. Sharma to
he is the person.
convince
I'm
us.
not- Of the record, I'm saying he is the person, but you know, probably in the.
No, we don't know because,
I'm not saying the lordship should presume now that.
no, not that. Because of some experience in that foreigners tribunal bench,
Yeah.
there we have seen that there may be
Yes.
same, two similar named persons in the
Father's
village.
name is not there.
Father's name
That,
is-
that witness book.
We'll leave it to Mr. Sharma to convince us. No, no, when your turn comes. Uh,
Now, Miller, your lordship will kindly come to page PW4. W4 at page 23. मैं सैयद अताउर रहमान पिता so and so मैं ईमान मोजार
Just a moment.
Huh?
Yes, now you're reading PW4.
PW4.
Yes.
Lord, I can skip over paragraph 1, 2, 3. Well, he has given who is he, who is the plaintiff and all that, then the defendant, manically on that. Then he knows মাটি to বাদী আৰু বিবাদীৰ মাজত গছৰ হৈছে মই মাটিটো চিনি পাওঁ বৰ্তমান বিবাদী দখলত আছে চাৰিসীমা এনেধৰণে he gives the yeah then উক্ত মাটিৰ পৰিমাণ page 24 এক কথা চৌধলচা মাটিৰ মালিক বাদী মোহাম্মদ লুৎফুৰ ৰহমান উক্ত মাটি কাইফাতুল্লাহৰ পৰা কিনিছিলে ৰেজিষ্ট্ৰি দলিল কৰি 1990 জানুৱাৰী মাহত উক্ত দলিল নম্বৰ ইমান যিহেতুকে উক্ত দলিলত মই এজন সাক্ষী আছিলো আৰু কাইফাতুল্লাহক চিনাক্ত কৰিছিলো মই এই মাটিৰ সম্বন্ধে আৰু কাইফাতুল্লাহৰ পৰিবাৰক চিনি পাইছিলো মাটি বিক্ৰী কৰাৰ সময়ত বাদীয়ে আৰু কাইফাতুল্লাহ মোৰ মাটি দেখুৱাইছিলে মাটি খালী মাটি আছিলে কাইফাতুল্লাহ বৰ্তমান মৃত তেওঁৰ বিয়া হোৱা ছোৱালী এজনী আমাৰ চৰাইবাৰী মুছলমান গাঁৱত থাকে উক্ত মাটি মোহাম্মদ লুৎফুৰ রহমান কিনিছিল 10,000 টকা ধন কাইফাতুল্লাহ বিক্ৰী কৰা উক্ত মাটি কাইফাতুল্লাহ 70 টকাৰ মাটি আছিল দেন পেৰা 4 ৰেজিষ্ট্ৰি দলিলখন দেখিলে চিনি পাম ৰেজিষ্ট্ৰি দলিলখন দেখিলে মই চিনি পাম উক্ত ৰেজিষ্ট্ৰি দলিলখনত মই সাক্ষী হিচাপে আৰু চিনাক্তকাৰী হিচাপে চহী কৰিছিলো সেইখন বাদীয়ে কৰিছিলো সেইখন বাদীয়ে কোৱা মতে প্ৰদৰ্শক 1 হিচাপে আদালতত দাখিল কৰিছে বাদীয়ে কোৱা মতে প্ৰদৰ্শক 1 হিচাপে আদালতত দাখিল কৰিছে আজি আদালত মই এই দলিলখন দেখিছো আৰু মোৰ চহী চিনি পাইছো Then, in all, he stated about the case of, the 20, that, how he gave positions and all that. There are 7 of their affidavit. ইয়াত উল্লেখ থাকে যে বাদী মহম্মদ লুৎফুৰ ৰহমানে মোৰ অনুমতি লৈ এই গোচৰত তেওঁৰ সাক্ষ্য দিবলৈ মোৰ নাম সাক্ষী হিচাপে আদালতত দিছিলে 2007 চনত। কিন্তু মোৰ কাণে নুশুনাৰ বাবে সাক্ষী দিব পৰা নাছিলো। বৰ্তমান মই অলপ শুনো। কাণে শুনাৰ বাবে আমাৰ পৰীক্ষা কৰাই কাণ শুনাৰ যন্ত্ৰ লৈছিল। Now the cross examination, why don't we come to page 24? At 24 or 28. মই আগে ৭৫ দিনত চাকৰি কৰিছিলো। মই মাজে মাজে মোৰ ঘৰলৈ মই আগে ব্ৰিটিছৰ দিনত ডিগবৈত চাকৰি কৰিছিলো। মই মাজে মাজে মোৰ ঘৰলৈ আহিছিলো। কিন্তু 1988 চনত পৰা মই মোৰ নিজৰ ঘৰ নিজাকৈ আছো। মই ছুটীত একমাহ মানকে থাকো। 1988 চনত গছৰীয়া মাটিৰ দোকান ঘৰ নাছিল, খালী আছিল। মোৰ ঘৰৰ পৰা গছৰীয়া জমিলৈ 1 কিলোমিটাৰ দূৰত কম দূৰত্ব হব। গছৰীয়া মাটিৰ দক্ষিণে কুতুবুদ্দিনৰ মাটি। তেওঁ মোৰ নিজৰ ককাইদেউ। কাইফাতুল্লাহ কিনা মাটি বাদীৰ বিক্ৰী কৰিছিলে। বাদীক বিক্ৰী কৰিছিলে। যিবিলাক মানুহে মোক কাইফাতুল্লাহে কিনাৰ কথা কৈছিলে তেওঁলোকে মৰিলে। কাইফাতুল্লাহে নিজৰ সত্ৰ দখল প্ৰমাণ কৰাৰ কাগজ পত্ৰ মই নিজে আদালতত দেখা নাই। এইটো সত্য নহয় যে গছৰীয়াৰ মাটি আদিম কাইফাতুল্লাহ নাছিল। এইটো সত্য নহয় যে গছৰীয়া মাটি কিনাৰ পাছত তেওঁ দিয়া নাছিল। এইটো সত্য নহয়। Then next third line, বাদীয়ে বিবাদীৰ মানিক প্ৰথম মাটি চোৱা চিতা কৰিবলৈ অনুৰোধ কৰিছিল আৰু 2 মাহ পাছত মানিক আলীয়ে বিচৰাত ঘৰ বনাবলৈ দিছিল। এই কথাবিলাক মানে মাটি চোৱা চিতা কৰা আৰু ঘৰ বনাবলৈ অনুমতি বিচৰাৰ কথা মোৰ ক'ত আলোচনা হৈছিল মই নাজানো, কাৰণ মই নাছিলো। He was not there. মই মানিক আলীৰ ঘৰলৈ যোৱা নাই। আগতে অনুমানিক কিমান চনত মানিকৰ ঘৰলৈ গৈছিলো। এইটো সত্য নহয়। These are all সত্য নহয়। মানিক দোকান থাকিবলৈ বাৰীৰ পৰা অনুমতি লোৱা নাছিল। এইটো সত্য নহয় যে গছৰীয়া মাটি মানিক আলীৰ। সত্য নহয়। Number of DW.
Yes.
PW2, PW, and PW. Page 31.
Yes.
প্যারা টু বাদ দিয়ে চাকরি করা পদক্ষেপ এখন অর্থাৎ বিক্রি দরে এখন জাল হওয়া আৰু বেআইনী ভাৰত গঠিত
Yes.
তুলনায় ইমান তাৰিখত গোসাইবাৰী গোটৰ মাটি বিক্ৰী কৰাৰ কোনো কৰ্তব্য বা অধিকাৰ নাই এই কথা দাখিল কৰা জবানবন্দী অৰ্থাৎ পদক্ষেপ 2 অস্পষ্ট হৈ আছে এক্সিবিট 2 জমাবন্দী অৰ্থাৎ 2 নম্বৰ পৰা অস্পষ্ট হৈ আছে প্ৰকৃততে ওচৰীয়াৰ পৰা লগা মাটি চিনাই নাপাওঁ তেওঁ ওচৰীয়া মাটি কোনোদিনে দখল কৰিবলৈ যোৱা নাই কাকতুল্লাই কোনোদিনে ওচৰীয়া গছৰ মাটি দখল চম্ভাই দিবলৈ যোৱা নাছিলে গছৰীয়া পট্টাৰ মাটি বটোৱাৰা হোৱা নাই পূৰ্বতে গছৰীয়া পট্টাৰ তাত মাটি নুৰ মহম্মদৰ আছিল নুৰ মহম্মদৰ মৃত্যুৰ পাছত আগত অন্য ককাই ভাইৰ লগত বিবাদী চুক্তি মানিকালি নামজাৰি হয় গছৰীয়া মাটি মানিকালি অংশৰ ভিতৰত পৰে মানিকালিৰ মৃত্যুৰ পাছত গছৰীয়া পট্টাৰ পাছত তাগত বিবাদী নামজাৰি হয় গছৰীয়াৰ মাটি আমি বিবাদী দখলৰ মাটি আমাৰ থকা ঘৰ আৰু গছৰীয়া মাটিৰ ব্ৰত এটাই আমি মানিকালিৰ পৰা উত্তৰাধিকাৰী হিচাপে পাইছো গছৰীয়া মাটিত 1980 চনত মানিকালিয়ে অস্থায়ী দোকান ঘৰ বনাই দোকান ব্যৱসায় 80 মানতে ব্যৱসায় চলাইছিল 1968 চনত মানিকালিয়ে উক্ত অস্থায়ী ঘৰ ভাঙি পকা 5টা পকা ঘৰ আৰু 2টা কেঁচা ঘৰ একে শাৰীত বনাই বিভিন্ন জনক ভাড়া দিছিলে এতিয়া ভাড়াত তেওঁলোকে ব্যৱসায় চলাই আছে গছৰ সংক্ৰান্তে ঘৰ কেইটাৰ ভিতৰত মানিকালিয়ে নিজৰ সত্ৰ দখল থকা গছৰীয়া মাটিত ব্যৱসায়ৰ বাবে বনাই দিছে তেতিয়া বিবাদী উত্তৰাধিকাৰী হিচাপে পাইছে জমাবন্দী আছে পদক্ষেপ গছৰৰ মাটি জমাবন্দী examination case 34 মোৰ বয়স 25 বছৰ পাঞ্জাব বিবাদীৰ নাম মাইনুদ্দিন তেওঁক মোতকৈ বয়সত সৰু বাদীয়ে চিনি তেওঁ মোৰ বছৰৰ মানুহ মোৰ গাঁৱৰ তেওঁৰ ঘৰ মোৰ ঘৰৰ পৰা বাদীৰ ঘৰৰ দূৰত্ব 1 কিলোমিটাৰ হ'ব লুৎফুৰ ৰহমান চৰাইবাৰী হাইস্কুলৰ শিক্ষক আছিল বৰ্তমান তেওঁ অৱসৰপ্ৰাপ্ত মই মেট্ৰিক পাছ কৰিছো চৰাইবাৰী হাইস্কুল মোৰ ঘৰৰ সন্মুখত That fact has been admitted by PW1 in procedure. Ajit Prabhu.
In that page 35, last 3 lines are against you.
Nur Muhammad 35 last. Nur Muhammadok 3 জন ছোৱালী আছিল মোৰ দেউতাৰ কিমান অংশ মাটি ককাৰ মৃত্যুৰ পাছত পাইছিলো নাজানো ককাৰ কেই দাগত মাটি আছিলে ক'ব নোৱাৰিম কিন্তু 277 দাগত আমি আছো Page 35 or 36?
35, that last part only, that he does not know how much land he got is from his father.
So that my lord will continue in the 35 also. লুৎফুৰ ৰহমানক চিনো লুৎফুৰ ৰহমানৰ ল'ৰা দুজনক তেওঁলোকৰ ব্যৱসায় মই এই কথা ঘৰ জন্মৰ পৰাই আছো ঘৰটো 3 কোঠালি আছে মোৰ থকা ঘৰটো মাটি 3 কঠা 8 লতা মান আছে দাগ নম্বৰ 177 পথা নম্বৰ ইমান মই থকা ঘৰৰ পূবে ঘৰ আছে পশ্চিমে স্কুল উত্তৰে বলিৰাম বৰা is the original person who purchased from the original pata দক্ষিণ পথাৰ আছে মোৰ পিতা মানিকালি বৰ্তমান মৃত দেউতাৰ উত্তৰাধিকাৰী আমি মোৰ বাইদেউ এগৰাকী জীবিত মোৰ ভাই এটা বাইদেউৰ নাম মীৰা বেগম নুৰ আহমেদ মোৰ ককা দেউতা আছিল মোৰ ককা দেউতা 5 জন ল'ৰা আছিল তেওঁলোকে হ'ল তাজুদ্দিন Ashraf, Orupon, Manikandi, and Faiz. This Faiz is not that Faiz. More Pakarata, Jadi, Uruga ke biya korisile mone jane. Then this I have read, জমাবন্দী ফাতুল্লাহ আৰু লুৎফুৰ ৰহমানৰ নাম পাইছিলো দেউতাক মৃত্যুত জমাবন্দীত কাইফাতুল্লাহ আৰু লুৎফুৰ ৰহমানৰ নাম পাইছিলো দেউতাৰ মৃত্যুৰ পাছত মোৰ নাম তথা মোৰ নামত নামজাৰি হোৱা বছৰটো পাহৰিছো মোৰ মা হাছিনা বেগম ওৰফে সোণমাই মোৰ দেউতাৰ মাটিটো তেওঁৰ মৃত্যুৰ পাছত আমাৰ মাজত ভাগ বতৰা হোৱা নাই কাইফাতুল্লাহৰ নাম শুনিছো তেওঁ চৰাইবাৰী স্কুলত শিক্ষক কৰিছিলে তেওঁৰ ঘৰ ক'ত মই নাজানো নুৰ মহম্মদ কিমান মাটি আছিলে মই নাজানো আৰু তাৰ কিমান অংশ মোৰ দেউতাই পাইছিলে মই নাজানো দেউতাৰ মৃত্যুৰ পাছত মোৰ মাটিত অংশ আছে প্ৰদৰ্শক এখন মই মোৰ শপতনামাত ক্ৰমে দিয়া দলিলখন ভুৱা বুলি বেআইনী বুলি কৈছো কিন্তু কাৰণটো উল্লেখ কৰা নাই দেউতাৰ মৃত্যুৰ পাছত যেতিয়া এখন নথিচ যায় তেতিয়া গম পালো যে প্ৰদৰ্শক এখন ভুৱা বুলি আৰু মোৰ ওচৰত এই বছৰ হয় তেতিয়া উকিলৰ ওচৰত চাপো প্ৰদৰ্শক এখন পঢ়া নাই কাইফাতুল্লাহৰ নাম জমাবন্দীত আছে মোৰ দেউতা পকা ঘৰ 5টা কোঠা 1988 চনত আৰু 2টা কোঠা ৰুম 1988 চনত বনাইছিলে 2টা কেঁচা 5টা কোঠা 1988 চনত আৰু 2টা কেঁচা কোঠা বনাইছিলে আৰু ভাড়া দিয়ে ৰাতুল দত্ত আমাৰ এটা ভাড়া ঘৰৰ কোঠাত থাকে ৰাতুল থকাটো কেঁচা ঘৰ বয়স 38 বছৰ সন্মান দিলীপ বৰাই মোৰ দেউতাৰ পৰা দোকানখন ভাড়াত আছিলে 1988 চনত দিলীপ থকা কোঠাটো বৰ্তমান অঞ্জলি বৰাই আছে বৰ্তমান হাতী কৰা নাই মই মোৰ ডাকুমেণ্টছত ৰাতুল আৰু দিলীপ হাতিয়া বুলি কোৱা নাই প্ৰদৰ্শক এখন বাতিল কৰিবলৈ মই ব্যৱস্থা লোৱা নাই এটা ৰুম 2টাৰ থকা বাৰাণ্ডা আছে কেঁচা কোঠা 2টা পকা কোঠাৰ দিশ দক্ষিণে স্বয়ংক্ৰিয় তাৰ পৰা কোঠাৰ কেঁচা কোঠা 2টাৰ পিছফালে এটা দোকান গোদাম আছে পুখুৰী আছে আৰু পিছত তামিলনাডুৰ মাটি লুৎফুৰ ৰহমানৰ ঘৰতে তিনি দিলে এইটো সত্য নহয় যে বিবাদীয়া জমি কাইফাতুল্লাহ আছিল আৰু লুৎফুৰে বিক্ৰী কৰিছিলে এইটো সত্য নহয় যে বিবাদী মাটিৰ খালী মাটি হিচাপে সমজাই দিছিলে এইটো সত্য নহয় যে বিবাদীয়ে মোৰ দেউতাক মাটিটো চোৱাচিতাৰ বাহিৰে খালী ঘৰ বাবে অনুমতি দিছিলে আৰু টেম্পৰৰী ঘৰ বনাই ব্যৱসায় কৰিবলৈ অনুমতি দিছিল এইটো সত্য নহয় অল denied বছৰৰ হোৱাৰ আগতে এখন উকিল নোটিচ পাইছিলো লাষ্ট 4 লাইন লাগে আমাৰ ওচৰলৈ গৈছে ৰহমানে ঘৰটো খালি আছে এই বছৰ হোৱাৰ আগতে এখন উকিল নোটিচ পাইছিলো 2000 চনত ডিচেম্বৰ মাহত কেঁচা ঘৰ ৰিপেয়াৰিং কৰিছিলো এইটো সত্য নহয় যে মই দক্ষিণ দিশত খালী মাটি 2006 চনত ডিচেম্বৰ মাহত পকা বাৰিণ্ডা বনাইছিলো এইটো সত্য নহয় যে তাৰ বিৰুদ্ধে মই কোনো লিখিত প্ৰতিবাদ দিয়া নাই আৰু শপতনামাতো এই কথা কোৱা নাই মই আবিদুৰ ৰহমানক চিনো
What is this reference to this notice in page 36? You were reading page 38. In page 36, about 6 lines from below.
I'm coming. Page 36.
6 lines from below. Devatar Mrityu Pisot.
Yeah,
Notice.
yeah.
What is this notice?
Because that notice has not been activated also. But probably there is a mention about it in the road trail. Let me just check.
No, I was just asking when you are reading page 38, it is the same notice, advocate's notice. No, we can't say. Page 38 is advocate's notice. And this notice at page 36, are they same or different?
Difficult to say.
Difficult to say. Okay, don't
Let me just check.
Uh,
Because there is some-
don't let it bother you.
he stated in para 11 of the plan regarding the previous month,
Peter's notice.
dated 13/4/2006. This is what, DW one has said, DW 2 and 3, they are the people who are in rent. Who is Ratul of stock. He took rent in 1988, that he stated. Then cross examination. अनेकाली मृत्यु हुआ 5 मुसलमान हॉल मैं एज 42 দুলানি গেছা কথাৰি ডাঙৰীয়া 20 বছৰ মান কোঠাৰ কাম কৰি আছে মোৰ অধীনত ৰাজেন বৰাই কৰিছিলে তেতিয়া তেওঁৰ বয়স 40 বছৰ মান আছিল মই 200 টকা ভাড়া দিওঁ ৰচিদ নিদিয়ে বা নলওঁ এই দিনে মই বহুত দিনৰ পৰা কিনো এই একেলগৰে ল'ৰা এইটো সত্য নহয় যে 1988 চনৰ পৰা মই কাৰ্যজনৰ কথাত ভাড়া টকা নাই ভাড়া ঘৰত দিয়া নাই এইটো সত্য নহয় যে দুলানি কাৰ্যজনৰ মিছা সাক্ষী দিছো He supports so far as my contention of the defendant that he is on rent from 1988. Because their case is that they purchased in 1990 and then they were allowed to look after and thereafter on being requested by us, was permitted to construct two kacha sets for doing business. Now DW3 is Dilip Bora. It is 44. বছৰ সংক্ৰান্তৰ ঘৰ কেইটা মই দেখিছো বিবাদীগণৰ ঘৰ বুলি মই জানো পূৰ্বতে মই সেই জায়গাত এটা কেঁচা ঘৰ আছিল তাত মানিকালীয়ে দোকানৰ ব্যৱসায় কৰিছিলে 1988 চনত বিবাদীয়ে দেউতাক মানিকালীয়ে উক্ত ঘৰ ভাঙি নতুন ঘৰ বনাবলৈ পাটপুৰ পকা দুটা কেঁচা মই অনুৰোধ কৰাত 1988 চনত হোটেল খুলিবলৈ মোক এটা লোন দিয়ে 1991 95 চন পৰ্যন্ত হোটেল চলাই ব্যৱসায় কৰি ৰুম মালিকক সমজাই দিওঁ মই মাহে 250 টকা ভাড়া দিছিলোঁ 91 আৰু 91 then cross মই
This DW 4 and 5.
DW 2 and 3 is there. We examine only 3 witnesses.
DW 2 and 3.
One is Ratul Datta, DW2.
They were at that point of time when they gave evidence, they were still tenants? No. When they gave their evidence, were they still tenants? No.
Just a minute.
দোকানৰ ব্যৱসায় কৰি আছো that means they are tenant
That other person, he
PW3 left.
PW3 left, he specifically stated in your chief itself. I think 88,
91,
91.
page 44.
Yes, yes. ও 1991 চনৰ পৰ্যন্ত হোটেল চলাই ব্যৱসায় কৰি এৰিটি ৰুম মানিক সঞ্জয় দিওঁ মই মাহে 250 টকা দিছিলোঁ নৰ্থ এক্সিজামিনেশ্যন মই ৰাজমিস্ত্ৰী কাম কৰোঁ 5 বছৰমান হ'ল তাৰ আগত ভোগালী আছো মই মানিকালি তেওঁৰ মৃত্যু হোৱাৰ 5 বছৰমান হ'ল বৰ্তমান গোলাঘাটত ৰাজমিস্ত্ৰী হিচাপে আছিলোঁ মই আগত দোকান চলাইছিলোঁ তাইজুদ্দিন সাক্ষী দিবলৈ গ'লে 1988 চনত মানিকৰ ঘৰ বনাইছিলে মাছটা উঠা মোৰ এটা পকা পিঠাৰ ব্যৱসায় কৰিবলৈ দিছিলে মই দোকান নতে সৰু আছিলোঁ 7, 8 মানত পঢ়িছিলোঁ এইটো সত্য নহয় যে মানিকালিৰ দোকানত কেতিয়াও বনোৱা নাছিল 2 and 3 so far as my lord defendant's case that this house was constructed in 1988 and since then these two persons were re-tenants has not been settled. In this context, my case with regard to the sale deed, my case with regard to the construction of the houses in 1988 and prior to that, in my humble submission, that has been established. And the plaintiff's case is that he was residing at 1 kilometer away, so it was not possible for him to look up there. My lord is belied by his own evidence. In the last part of the cross examination, he said that his school is just opposite to the disputed land, and he used to see them. There are certain other evidences, I have already pointed out. But how far your lordship will, the second appeal will look into it, or not, I leave to my.
Because you see, something which is very tangent, nothing to do with this matter, not even close to it. Many years back, 3-4 years back, my Bangalopian attached to me was very happy, and he said that his daughter could speak in English. Young daughter, class 3-4, could speak in English. I said, what is big about it? Why are you so happy? He said that prior to that, the teachers do not come to school. That year, Gunotsav started. And he said that now all the teachers, they have left their agriculture, they are coming to school. And now in that village school, before that Gunotsav, the students were taught to speak in English, and her daughter could speak English. And that was a happy moment for my peon. He was very happy that a little girl could speak English. So you see, that gives the idea that why a teacher whose school is opposite the land cannot look after the land. It's just in lighter note, but this Gunotsav had a very telling effect on my peon. He was very happy when his young daughter could speak in English. He had a sense of satisfaction that his daughter is going to school.
I would like to add one fact more, but though that is not in the evidence and all that, but I have given a type copy of the Jawabandi.
Normally, yes.
I have calculated from there, and I have found, that the total land comes to be 2 biga, 1 kata 6 land.
You see in your calculation number one, what is the difference then to 2 biga?
The total comes to be 2 biga 1 kata 6 lakhs.
216.
Whereas this land should have been 1 biga 3 kata 9 lakhs.
No, 1111.
So 1111, then my lord, the same thing will happen, my lord.
No, it's okay. 1111.
One kata 18 lakhs will be
Huh,
also.
18. Now from 216, 2 biga 1 kata 16, the 6 lacha. What is the difference?
My lord, I have taken it to be 1 biga 3 kata 9 lakhs because actually I have taken 1 kata 18 lakhs to be included. The difference comes to be 2 kata 17 lakhs.
2 kata 17 lacha.
Mati ki one. And the disputed land is 1 kata 14 lakhs. And in my evidence, page 31,
Just a moment. You see, Mr. Agarwal, there may be some discrepancy. I'll tell you why. Please come to page number 2 of this comparison.
Huh?
Page 2 of this Jamabandi.
Right.
Here you see 10 lacha, 10 lacha in the name of,
Yogeswar Gogoi.
in place of 12, correct? Now, this is one. Second entry, you will find this page is 2, second entry, 1 kata 10 lacha, and sixth entry of 1 kata 10 lacha. This is same land being transacted. First, serial number 13 has purchased, then 13 has sold. That you have excluded. Okay.
Subject to question, Lord, I have excluded those.
Okay. Okay.
And my lord, I have marked in bold, your lordship will find these two are same practically. I do not know, but the dates are different. In the first page, your lordship will find third entry, 1 kata, fourth entry, 1 kata, and fifth entry, 1 kata.
Yes. Yes.
This is one
5, 14, 15.
Abdul Ghafur purchase. Then Imran Hussain
Same
purchase,
5, 14,
then
15.
Yogeswar Gogoi
Correct. They're same.
But your lordship comes to page 2 also. This
Yes,
is,
I've seen that it's same.
because I have made it bold, my lord, so that it can be, my lord, just pointed out to my. And in my evidence, in para 2, I have stated in chief in this regard, not in so many words. এই কথা গোসইয়ার দাখিল করা জবাববন্দি অর্থাৎ 2 নম্বরত অস্পষ্ট হয়ে আছে। বাদী দাখিল করা দখল 1 খন অর্থাৎ বিক্রি দলিলখন যা ভুয়া আৰু বেআইনী। সাইফাতুল্লাহ ইমান তারিখে গোসর মাটি বিক্রি করার কোনো সত্য বা অধিকার নাই। এই কথা গোসইয়ার দাখিল করা জবানবন্দি অর্থাৎ 2 নম্বর পদক্ষেপ 2 অস্পষ্ট হয়েছে। He has not very specified.
Okay. So in summing up, what you will say?
My humble submission in a whole, my lord, so far the my lord, issue number 4 is concerned.
Yes. Take a break and come back.
Take my lord to the finding of both the.
I'm confining basically on decision number 4.
I think speaker is switched off.
I'm confining, my lord is hearing.
Yes.
I'm confining, basically to issue number 4. Because my lord, earlier occasion when it started, said that it is the issue number 4, whether the plaintiff has right title interest. There were 6 issues, 7th issue was my lord added regarding the permissive occupation. And my lord views was that both the things can't go together. He cannot have a right to have claim that I am permissive occupier. Now, we not hear the other issues, whether suit is based barred by limitation, whether suit is based for non-joinder, whether the plaintiff's right title interest over the suit land, whether the plaintiff is entitled to a degree for class for suit land incidentally by evicting the defendant. So, issues number 4 and 5. Special questions of law framed also basically goes to the exhibit 1.
These additional issues were framed
Yes.
when?
At the time, by the appeal court. My lord, your lordship will find that at page 38.
in 38,
No, this, the reference to that is coming at page 51. Page 51 is the appellate judgment, but why this has come back again? I forgot the track.
not, the Milord suit was agreed, but this issues were decided. Now, Mr. Lordship kindly stand, Milord Albert, we filed an appeal. That was remanded. By
No, appeal was allowed.
appeal was around. The decree was set aside,
Yes.
the matter was remanded with a direction that decide on the issue. If necessary, take evidence. My lord may just read that.
Yes.
That will be important because my lord, one of the arguments.
Oh, acha, page 43. Okay. I get it.
Page 43. Your
Huh,
lordship,
huh. Okay, that's why your argument was on the last occasion that the entire judgment was set aside, and therefore
your lordship
that.
says that
Huh.
sometime. Even that proposition also, that though one side it said that the entire judgment is set aside, then he was said that no, you take evidence on such and such issues and then decide and send back the case. So my argument was that, you know, it was a remand under order 41 rule 23 capital A, and not a remand under 41 rule 25. That was my one of them. That's what, you know, the trial court after remand decided only the issue number 7, that was the addition. My lord referred to some decisions also at that point of time. I have taken note of, but those decision directly does not go to that question.
No, because you see,
Whether
let us take an example. Like here, right title interest and issue number 7 is permissive occupier. Two different things, which have bearing on each other. Because if you admit it is what you call permissive occupier, then you admit that he is the landlord.
Yes.
Now, if I remand the matter back for decision on issue number 7 and do not set aside the judgment, then
Yes.
this issue can't be decided otherwise. If I am the trial court and I am receiving this order that the judgment is not set aside, now you decide on issue number 7. Perhaps I can't decide it.
what happens, my lord, subject to correction. One, it is not the entire case is remanded. If the case is remanded, that this is the issue which could.
I get it. I'm
which
not.
could have happened.
No, I'm not oblivious of what you are submitting. But you see, let us take this situation here. I am the trial court. I get a matter on remand. The judgment is not set aside, so far as right title and interest is concerned. And now I have to give a judgment on issue number 7, which is permissive occupier. Now, the question is, how will I proceed if I am the trial court?
Proceed, well, your lordship will kindly see in that is true. My lord is basically saying that, my lord, if right title interest is decided already by me. Now it says that you frame a issue on permissive occupier. Both these things can't go together. Because, my lord, I am denying his right title interest,
Huh.
his ownership on the land. So, my lord, the question of permissive occupier will not come,
Will not come.
not come.
So
Only
therefore, you
right
see,
title interest will come.
so therefore, you see, if that judgment is set aside, only then issue number 7 can be decided.
The other things will not remain, my lord. The decision on the, my lord, the issue number 4 right title.
Correct. That
So
point.
that's what I'm saying.
That
That will not remain then. My lord is rightly pointing out to me, my lord. That, my lord, if it is not set aside, you will not be able to, my lord, the trial court will not be able to decide this issue because he has already decided one issue. So this what my argument is that in fact, though it was said that no, it is set aside. And then again it said that no, you give only your finding on issue number 7. Bro, that is not correct. But I'm not making a submission that your lordship will remand back the matter. Because, my lord, after all, this matter is going on since long.
no, remand is something I would normally not do.
I'll also not make a submission to that effect. But my lord will kindly see, in this situation, that judgment was, the judgment of trial court was not before the appellate court, when we came in second time in it. And my lord, if your lordship kindly, my lord, I have read again in the yesterday, my lord, the appellate judgment, your lordship, I'll see. He has considered that we have admitted everything. But
Come to
appellate-
that part, come to that part.
Appellate judgment. That appellate judgment is page 51. May I come to directly to page 55, that is issue number 4.
Yes.
Rather, may not the trial court elaborately written, my lord. His judgment may be correct, may not be correct, that is, I am not on that. But elaborately written something. I'll come to the trial court judgment also. On the issue, the learned counsel for the response took the help of book on Muslim law of India written by Dr. Tahir Muhammad. The reason for this is that the appellants made a claim that unless there is a partition of the property, late Kaifatullah cannot sell the suit land to the respondents. In chapter 12, page 238 of the book, it says that when Muslim father dies, and he heirs do not divide his properties and continue to keep their joint position, then they are called tenants in common in specific sects. But case wise not that, Lord. Case wise that may not that there are 16 pattas. There are 16 pattas, and 16 pattas, the entire land is in one patta. So unless and until the patta is divided, in whose position, in whose who is having right title interest over what part of land, nobody knows. That was the basic case in the written statement. It was not the case that they have not. Now I shall take up the case of the appellant. They stated that their father Manik acquired the suit land by way of gift. The appellants also claimed that this land originally belonged to the father of late Manik I have found that appellants failed to prove this fact by adducing evidence. Well, nobody challenged that we got the land by way of gift. So the question of proving that does not arise. I have found that appellants failed to prove this fact by adducing evidence. Appellant Faizuddin in his evidence stated that the sale deed executed in favor of respondent is false document. In spite of that, the appellants never adduced any evidence to prove the fact. At this point, I agree with the submission of the learned counsel for the respondent that the appellant never disputed the factum of sale of the suit by Kaifatullah to the respondent. Exhibit 1 is the sale deed. As the sale deed has not been denied, I have no reason to hold that the sale has been admitted. I have no reason to hold that the sale has been admitted by the appellant. I do not know what he is writing. I have reasons to hold. So I'm sorry. I have reasons to hold that sale has been admitted by the appellant. If your lordship reads the written statement and the cross-examination, in my humble submission, it clarifies that we are challenging that.
You're disputing only the right of him to alienate. Only that much. The sale deed is not under challenge, but you are merely saying that he did not have right to transfer.
That goes to the root of the matter. If I do not have any right title interest to sell the land, because I am challenging the authority in so many words, it's not written the right title and interest. I am challenging Kaifatullah's right or authority to sell the land. It goes to the root of the matter. I do not have right title and interest over the High Court's land, but I make a sale deed too. But thereby the right title and interest will not pass on the purchaser. That is in my humble submission, that is the basic case that has been made out in my. And in that view of the matter, it was when it was taken in the written statement itself, it was the bounden duty of the the plaintiff to prove the purchase made by Kaifatullah. Because he in the Ramjari, it says that Kaifatullah's mutation was based on purchase from Baliram Bora. the title over the land, this is the registered sale deed, and by virtue of section 54 of the transfer property, the title over the fruit land legally got transferred to the respondent. The respondent thereby acquired the right title and interest over the fruit land. I answered this issue in affirmative after recording my agreement with the decision of the learned trial. So this is the not finding of the appellate court as far as issue number 4 is concerned. Rest I am not reading.
But please come to section 43
53 of the not TPA.
TP Act.
Yeah.
This 41 and 43 will interplay. Transfer by ostensible owner, wherewith consent express or implied. The person interested in property, a person is ostensible owner of such property and transfers the same for consideration. The transfer shall not be voidable on the ground that the transfer was not the authorized to make it. So if let us assume that the original owner with a tacit approval allows him the vendor to sell it. So therefore, that transfer is covered by 41. Now come to 43. Transfer by unauthorized person who subsequently acquires interest in property transferred.
Where a person fraudulently or erroneously represents that he is authorized to transfer certain old property and professes to transfer such property for consideration. Such transfer said at the option of the transferee. Operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists.
So here the original owner did not come and say and challenge that sale. Therefore, that sale is not fraudulent. And therefore, if not under 41, under 43, it will be covered. Because if a person whose name has and thereafter entered in the Jamabandi as a owner, he subsequently acquires title. Because that owner has not come and said disputed the title was not validly transferred. So if that is saved under 43.
Into the illustration.
Hmm?
Illustration.
Yes.
Very important. In so far 43 is concerned. A Hindu who has separated from his father, B, says to see three fields, X, Y, Z, representing that A is authorized to transfer the same. Of these fields, A does not belong to A. It has been written by B on the partition, but on B dying, A as their obtains A as heir obtains G, C. C, not having decided the contract of sale, may acquire A to deliver G to. So this is a situation different, because here the situation is different.
No, here delivery is already completed. So therefore, this will not come.
Delivery completed will not.
But still, you see, it is the transfer which is validated. If that is not challenged, the moot point here is that if that sale is not under challenge, then the right to direct him to give possession, that right accrues. That means the sale is validated, even if the transfer is fraudulent or erroneous. He claims that he has right to do it and he has done it. Sale deed is not under challenge.
Sale is still subsisting. Sale is not challenged, not cancelled.
No, not cancelled.
Now it says that a situation that I have no right title interest at the time when I sold it. But later on, will not I acquire? The contract subsists. So that will validate my subsequent acquiring the right title interest will validate the earlier transfer made. So probably I have.
Yes, right. Absolutely right. Absolutely right.
So it is not the case here,
No, here the vendor sold it in 1978. Let us assume. No, his vendor. I'm saying sold in 1978. However may, sold in 1978. So the subsequent purchaser in 1990 sells the land again. So therefore, you see, the original vendors have not come and sell the transfer. So therefore, we'll have to presume that the transactions are all validated. Now, if that view is taken, and the defendant does not challenge, does not file a counterclaim to challenge the validity of that sale deed, that sale deed for all purposes remain, and therefore you are at a disadvantageous position.
It's not common record. Sarfatullah purchased from whom? The deed is not before the court.
Correct.
But in that situation, my lord may have a, yes, that since Baliram Bora, he said that Baliram Bora sold the land. Baliram Bora did not say anything. So the sale is valid. So
Till somebody denies the title.
subsequent,
For all purposes, there is a transfer, because you see what happens is that in not here but in Barak Valley, there are two tenancy acts which are followed, including Select Tenancy Act. Now there is a unique situation where you can even transfer the harvesting rights, the jot rights can be transferred. And therefore, in those cases, experience shows that a particular plot of land can be transferred many times. They also have the unique, it's an accepted part of Select Tenancy Act that the transfer can be conditional. And therefore, what happens is that they give the jot, sell the jot rights and then have it back after a year. So that is the tenancy which they are creating, and it is validated. So there are 2-3 litigations where there are multiple transfers, multiple transfers and multiple litigations with particular lands of stretch of land of Barak Valley. From there, the experience gathered is that once that sale is otherwise validated, it may be right, it may not be right, but somebody has acquired a title. And if that validation otherwise can be accepted for more than a 12-year period, then in Article 65, the validation of the transfer and the possessor's right under Article 65 stands. So after this recent judgment of the Supreme Court, where it has been validated again, right to sue for adverse position, that has been validated now. So we'll have to presume that the person who is in occupation of the land, here you are trying to say that the land was never in their occupation.
their occupation and number one will not be Baliram Bora purchase. But if your lordship looks into the, because there is no other evidence on record.
Nothing on record.
So lordship looks into the Jamabandi. Baliram Bora purchased 1 kata 14 lachar. In date is in 77 from one Asraf Ali. That is one of the Manik Ali's brother. My mother defendant's father's brother. Then secondly, another note I have given in page 2, that is 1 kata 18 lachar. First, your lordship will find the first entry.
Yes.
From Asraf Ali. Now, my lord, your lordship, that evidence has not been taken, or that is no, yeah. That
No, which one?
first 1 kata 14 lachar. First page, first
First page.
First page, first page.
Ashraf Ali.
He purchased from Asraf Ali. Well, what I'm trying to point out here is that after death of Nuruddin, the 5 sons, they acquired the entire land by way of gift. And thereafter they are in position. Out of them, some of them sold their land. Some of there were multiple purchase, multiple sales and all that is shown from here. Now, Asraf Ali was one of the original Pattada by virtue of gift from Nuruddin. Then Asraf Ali, again, your lordship will kindly see page 2, that 1 kata 18 lachar.
Entry number?
Entry number 1, 2, 3, 4, 5, 6, 7, 7th entry.
Yes.
So here 1 kata was located in the name of Baliram Bora. On the basis of purchase in place of 2, Samjur Ali.
Yes, in place of Tamzur Ali, Boliram Bora, yes,
Tamjur Ali.
yes.
So look, he was also one of the, the original Patadar. Now, look, here what I am trying to point out to my room. That look, I am also the son of the original Patadar, one of the son of the original Patadar.
That means Ashraf Ali.
Not Ashraf Ali. Ashraf Ali not, but it has come in the evidence that Nuruddin's son. Look, may I just point to my room.
Nur Muhammad,
Nur Muhammad was the original Patadar.
yes.
So, I think the Nur Muhammad. So, no, here, give it to page 6 in the documentary.
Yes, I've seen that,
Yes.
Nur Muhammad.
Then Tamjur Ali. That one katha, 18 lasha. Tamjur.
No, but you see, the legacy is not there. Nur Muhammad, his legal heirs are not there as legatees.
16 of WS, there is there. There are 16 of WS. Legal heirs, so for the legal heirs of Nur Muhammad is mentioned.
Name of Nur Muhammad are there.
Legal heirs of
Page
pilot 20 man. 20.
29,
20.
20. That is not acceptable.
No, your lordship will kindly see page 8 also of the evidence of PW1.
No, this you see, Mr. Sharma. The para 16, you are referring to Nur Muhammad's 5 sons. One is Taznur, correct? Come to this Jamabandi comparison which Mr. Agarwal has made. Doesn't have that name.
Final, the type copy, I don't have the name.
No, it's okay. But in page 6, you have given this original one.
There.
No, Taznur is not there.
Is it there?
No, no.
Names are sometime written.
No, that's why I said some experience in that foreigners bench
Yeah.
has made us look.
State number 2, my lord.
Tamjur.
Tamjur. Tamjur is different from Taznur.
Tamjur is different from Tanjur, but my lord will kindly see. In the
You see, their father's name is not given.
father's name are not given. Pita, these all are blank.
So far, my lord,
Then Taznur Ashraf Kanwar Ali.
others are
Father's name not given. Then it is
Ashraf Ali,
Faz,
Akbar Ali,
Faizat
Malik Ali.
Din Ali. Faizat Din Ali. Again, father's name is not there.
Up to 2 to 6. Others are not there. Serial number 2 to 6. But so far, in comparison with the statement made in para 16, the WS.
Yes, it is there. Printed hunter. I have taken printed copy also. तो ये पर वो है ना? हैं? But this was taken while the case was going on, my lord, last occasion from the my lord portal. Because lordship kindly turn to page, next page. Lord, if your lordship 14, serial number 14,
Yes,
Noor Muhammad,
yes.
then Tagnur,
Father's name Noor Muhammad.
Ashraf Ali,
Okay,
Noor Muhammad, then Son Kumar Ali, Pita Noor Muhammad,
okay. Name is there.
Manik Ali, Pita Noor Muhammad.
Okay.
And Lord, that is the admitted case of the plaintiff in cross-examination. He stated that yes, the property devolved after the death of Noor Muhammad to the 6 sons. And Faizar, not from 15, 16, 17, 18, 19. These are the five sons. Noor Muhammad, Tagnur, Ashraf, Sonkuar, Manik Ali, and
You see the
Faizar.
difficulty, Mr. Agarwal. Come to page 31 of your compilation of PWs. There, this statement is not made
Right.
in the written statement.
Right.
Page 31 of your compilation of evidence.
Achha, I'm coming. Page 31. Yes, madam.
Here, those legacies are not even averred.
He has not ever.
But this WC is by Faizuddin Ahmed.
He has not ever.
He is not
He has not
made in
ever.
statement
But
there.
not on cross-examination. Huh? 30? 35. Achha, na, photo. So cross-examination, it is there. My lord, you'll find in page 35,
Yes, last part.
middle part. You know?
हाँ, मोर कोकादेव पाँचজন
কোকা দেউতা আছিলে, কোকা দেউতাৰ 5 জন ল'ৰা
তেওঁলোকৰ তাজউদ্দিন, আশরাফ, হৰুকন,
মানিক আলী
মানিক।
আৰু ফাইজ। Not this Faizuddin, you know, dependent number 1. And the fact has been also admitted by PW1 in his cross-examination. At page 8. So he has not respected the name.
ছয়জন ল'ৰাৰ নাম।
So I don't think I know, but
Page 8, first part.
okay.
Okay.
It is there also page 9, your lordship will find. Do it to উল্লেখ আছে যে বিশ নম্বৰ দাগত এক কথা মাটি তজনুৰ আশৰাফ মানিক আৰু লগত যুগান্তৰ নাম আছে, that is different, that same. But what I'm trying to make a submission, you know, because I am already a patadar and having, you know, then there. My case is not that I have purchased from somebody. Because I am by way of gift or whatever, by way of gift, Manik Ali got it. From Manik Ali, I got it by way of right of inheritance.
You know, What was that?
That's no.
No, what is it first transaction?
First transaction was Baliram Bora.
Bolirampura.
Ashraf Ali sold to Baliram Bora.
This is page 2. 1, 2, 3, 4, 5, 6, 7th entry, right?
The first entry, you know. 1 kata 14 lacha in page 1.
Ashraf Ali.
That is one. First.
No, Noor Mohammed comes from where?
Noor Muhammad, my lord, it is shown there, but nothing has been shown here. Noor Muhammad's name is there. I have not written any names, my lord.
No, it's okay. The Noor Mohammed,
Noor Muhammad,
his land is not sold.
Huh?
His land is not sold.
no, he died.
No, he died
And then the
his
entire land was, my lord, gifted
to
to these persons, my lord, all these sons. I think
Give-
it is there, probably there. Let me just find. The lordship will find in page 10,
page,
page 10 of the, my lord, documentary volume.
this
No, not that. Document.
documents.
Comparison of document. But I have just for the purpose of calculation, I have made the chart, my lord,
No, no, it's okay.
not given the entire detail.
Serial number,
The first number, Shikha, Ekoprati Hamada. Page 10, my lord.
page 10, yes.
চিঠার উপপ্রতি হামারতার 24/14/1970 তারিখত হুকুম মতে ভট্টার সামথিং দাগত দান হচ্ছে নূর মোহাম্মদৰ ঠাইত 2, 3, 4, 5, 6 নম্বৰৰ নামত নামজাৰি হয়।
Yes.
That printed, my lord,
Okay, so 6 Faizuddin is there. Faizuddin is already there.
that Faizuddin is not, my lord, the defendant number 1.
Okay, then
That is Faizuddin. Manik Ali is there, my lord, your lordship will find.
Manik Ali name is struck off.
Manik Ali, after the date of Manik Ali, my lord, the part which Manik Ali was holding was devolved to, my lord, defendants.
No, here again there is a problem. The type copy which you have given me, first page 1, first bold letter,
Yeah.
1K. Land measuring so and so was mutated in the name of Abdul Ghaffar on the basis of purchase along with Manik Ali.
Which, my lord?
So this page, this type copy
Acha.
of Jamabandi.
Huh?
First bold 1K.
Yeah.
This one. Type copy.
Oh, acha.
So Manik Ali,
One kata.
1 kata.
And then it was again, Abdul Ghaffar sold it to Imran Hussain.
No, I'm just examining the name of Manik Ali.
Yeah.
So Manik Ali, this is along with Manik Ali. So therefore Manik Ali must have more land, and therefore 1 kata was sold,
Yes.
and therefore the purchaser along with this remains. So only if you can find out what is the land sold.
Third, there is a distinction, last occasion, my lord also pointed out. Along with,
along with.
and in place of. I have maintained that fact here.
Okay.
As per the Javabandi. If your lordship find the entry number 1, 2, 3, 4, 5, 6, by order dated itna, land measuring 1 kattha was mutated in the name of Yogeshwar Gogoi on the basis of purchase along with Tamjul, Ashraf, Manik and Faizul.
Manikali name remains.
Manikali remains. If you lordship kindly see, because this chart basically of sale, when the defendant's name came into it, that fact your lordship will find. Itu na itu pai ini menjadi dalam bola. Itu tun tun itu ki gokoi koi gokoi bisa bola tunani bisa lordship kindly see pada ये देखो the Javabandi, the name of the defendants appear at serial number 27 and 28. The chart prepared by me is basically with regard to sale. And that has been extracted from Exhibit 2. And the name of the defendants were mutated in 25/1/2001. Eight 491 and then 25/1/2001 subprofessor 1/5/2003 तारीख और हुकुम पट्टा दागत उत्तराधिकारी सूत्रे 5 নম্বর স্থল 26 27 28 নাম নামজারি
25/1/2001.
Yes. Page 16 of the the note is given, endorsement, page 16.
No, but this SMS Javabandi you gave me. SMS Javabandi,
That printed one.
printed one. 1, 2, 3, 4, 5. Serial number, page number 5.
Yes, madam.
তিন নম্বর স্থলত এই উত্তরে 20, 21, 22 20, 21, 22. It does not relate to that Manikali.
No, no. But see is Amona. No, but please, your lordship will that your lordship will find here. You will find in page number. Page number 7.
Yes. Okay, 24 Star 25
But the serial number 25 here has not made.
doesn't match.
But in this minute, in the exhibit 2, which has been exhibited, if your lordship kindly come to page 10. Page 7 first, page 9 first, my lord will kindly look at page 9.
Yes.
26, Srimati Sonmai Begum. 27, Faizuddin. 28, Mainuddin.
Yes.
These 3 persons, I am just pointing to my lord. And then my lord will come to page 16. My lord, the second note, 16, तारीख 25/1/2001, तारीख 8/4/2091 और तारीख 25/1/2001 চক্র বিষয়ের 1/5/2003 তারিখের হুকুমতে পট্টা দ্রব্য ডাগত উত্তরাধিকারী সূত্রে 5 নম্বর স্থলত 26, 27, 28 নাম পদ। And 5 is in this Jamabandi, 5 is Manikari.
Okay. This ought to have been the exercise in the trial court.
Huh?
This ought to have been an exercise in the trial court,
Not here.
not here.
Second attempt. So, this I understand.
Okay.
I do not know why the exercise is not being done well.
Comment from here would not be appreciated.
Huh?
Comment from here may not be appreciated by.
My lord and me also, my lord, we came from that place. It's not that we have not practiced there. My lord practiced on the civil side in the trial court.
No, you see, well, not that. That is the sad part.
Huh?
The sad part is that in civil matters, the effort to understand the what you call the entries is not normally made. The what you call the relationship when I asked you the first question about that mutation, you could refer to mutation by Chitta and mutation by way of an application. Because to me, that will come under Rule 115 of the rules for settlement. So you, unless we have a track of the provision and track of the entries, we'll not be able to understand what is.
That's, if you don't have experience, my lord, it's difficult. Because, my lord, I have the experience because, my lord, in the earliest point of time,
No, that
my lord, I used to go there, my lord, and to see the chithas and all that. Because, my lord, in some cases, some, when the big companies and others, they purchase the lands, then they want a
Search report.
search report. I remember once Mr. BRD, he was for some bank. Then the bank was to give loan and all that, some property in Tinsukia. We were very close to each other. Then he told me that we were able to go to Tinsukia. I was a junior, I said, why not? Good fees was given all that. I gone there and I made a search and all that, and I give a detailed report. Each entry I have checked. So the experience goes from there. It's true, my lord, your lordship, unless and until people go and see an advocate, it will not be an difficult.
And we are finding out the chithas and other things from the Malad Mandal office and all that. It's a horrible task. Horrible task.
Yeah, right.
And then doing this 107 cases, 144, 145 is also a different plan. I have experience of all those. 133.
Right, 33.
Yeah, please. What is that? One now.
And there's one very astonishing fact. The lawyers practicing in Dimapur and those matters which go to the Kohima bench thereafter, Dimapur lawyers are what do you call it, very thorough in Assam land and revenue regulation. That much of thoroughness lawyers in the state of Assam is not there. But the extent of their understanding of the land and revenue regulation, Assam land, because that Assam land and regulation is followed in Dimapur, cadastrally mapped area. So that is being followed for Dimapur. And they are far, far more better equipped in Assam land regulation than lawyers in this part. In the courtroom, I was asking a question about this. You see, there's a set theory that once once the civil court takes up the matter, then revenue should hold itself,
I guess.
and it is that. But there the lawyers they were arguing that no, it is a parallel and you can't restrain that because of the fact that these orders under this are appealable before the state government. So therefore, the channel is different. You decide the right title and interest. But that part has to be concluded because my right to have my name entered is there. So whether somebody wins or loses is something else, it can be struck off. And the amount of energy spent on that explaining this part made me to believe that the argument is otherwise right. Right title interest merely because the civil court has taken cognizance may not be the end of that chapter because that is for the state government to do. And then those many of the provisions of some land revenue reason why that has to be done, and that was explained. And the thoroughness with which it was explained still reverberates because it is I'm narrating this experience which I had about 4.5 years back. That much of authority they have in this land and regulation, they could explain seamlessly the various provisions, interlinking it, and saying that why that part of the theory may not be correct.
But in some of the provisions of land revenue regulation, it says that when a dispute you can be referred to. So it is not that at all the occasions they have to decide it on.
No, but there's a normal thumb rule that when it is a civil court which has taken where the list is there, then revenue authorities should not touch it. It will be the decree of the court which will then prevail. That is the normal theory. But a beautiful argument made to counter that, saying that it was their duty to have their names, otherwise third-party rights are created. The people do not have notice about the entries made, and therefore third-party interests are created in respect of the land because there in the portion, some lands are transferable in the cadastrally mapped areas. So they say that their interest will be hampered. So therefore, that
Let
that
the
should
entries be made, let the civil court decide right at the entries.
that will not be
If the civil court
implemented.
decide the right, it will take its own.
That may not be implemented, but the entries should be prevail. Otherwise, it does not constitute a notice
Notice,
about that land.
Because I'll take the Jamabandi from there, I'll see.
A very beautiful argument was made. But besides the point, that's all in your matter. Anything more? Anything more?
Factual part and other things are concerned, I have concluded.
Okay. We'll fix some other day because Mr. Agarwal will not be here in the second half.
Can it be tomorrow?
No, not tomorrow.
It may not go to.
No, because there are few matters already fixed.
We go to
Okay,
Bhimu
Devang.
Road, 18th can be,
Huh?
18th,
18th,
18th after the opening.
After
By
the
the
opening.
time I'll be also free from this.
Okay. The submission of Mr. K. Agarwal, Senior Counsel, assisted by Mr. D. Akram, the counsel for the applicant is concluded, reserving right to reply. Mr. M. K. Sharma, the counsel for respondent is present. Next panelist on 18,
23rd.
23rd. Okay.
Tuesday.
23/1/2024 for submissions made, submissions by the learned counsel for the respondents.
In the meantime, if I have something to show about here, just note. I'll just give it.
Okay, we're not noting it. Just
Let it be there, because so far, sexual part and other things I have concluded.
list on Swing as part of matter. Okay.
All right.
I may be 5 minutes late in coming too. Yes, item 3.
Have you got lordship?
What is the ground?
The ground is, the minor is residing in Bongaigaon Lordship since 2016. And as per section 9 of Guardian and Words Act Lordship, if the application is with to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides.
Okay. Heard
And she is
Ms. Mahar Saha, counsel for the petitioner. Transfer of guardianship proceedings, page 1, from Court of Principal Judge Family Court, Kachhar, Silchar, to Court of District Judge, Bongaigaon. Notice take steps within 2 days. Postal receipt track number and stay. Proceedings also stayed. Okay, but take steps. And certified copy has to be produced before the court, before the trial court. Item 5. Yes.
Lordship, in this case, I am challenging the order dated 22/11/2020.
How many adjournments you have taken? Give me the dates of adjournment.
Lordship, I have taken the adjournment, Lordship, 5/7/2023,
5/7/23.
5/8/2020.
No, first of all, when did you receive the summons?
Lordship, I received the summons. Lordship, 21/6/2023.
21,
21/6/2023.
21/6/23.
Yes. But Lordship, at that time was service of summons, that plaintiff did not serve the copy of the claim.
Okay.
Then Lordship, I filed the petition on the 5/7/2023 seeking.
Yes. Then
Then Lordship, 5/8/2023. Then Lordship, 7/9/2023.
7/9/23.
Yes, sir.
Yes.
Then Lordship, 21/9/2023. And the Lordship, 8/11/2023. Next side 11. 8/11/2020.
Just a moment. You have annexed the order sheet of 20,
Yes, Lord.
21/9/23.
Yes, Lordship.
Where is
Annexure
that?
nine.
Where is that?
Lordship, annexure 9, page number 9, 49, Lordship.
49.
Then census fixed on the 8/11/2023. So that when we furnish the document, copy of the documents on the 8/11/2023 to the defendant's lordship. Here the lordship, the case was fixed on 22/11/2023. And the lordship, on that day, lordship, I was present, but the court proceeded the matter expert lordship.
Okay. But Mr.
Yes, duty.
As the only counsel for the petitioner, by filing this application under Article 227 of the Constitution of India, the petitioner has assumed the order dated 22/11/2023, passed by the learned civil judge within bracket senior division, bracket close Goalpara in PS 47 of 2023, comma by which he appear for seeking time to file a written statement was refused and it was rejected. And the suit was ordered to proceed ex parte against the petitioners dash petitioner dash defendant. Petitioners, yes, petitioners, defendant. If notice returnable in on so and so. Steps within 2 days. Postal receipt track report. Consider the prayer for interim relief of staying the proceedings of suit. Having noticed that as per the case projected by the petitioner, copies of documents were furnished only on 8/11/2023. And the next date of 23/11/2023 was the first date of filing of written statement. The court is inclined to stay the further proceedings of TS number 47 of 2023 pending before the court of so and so till the next date of listing. Next paragraph. The petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court. List on so and so.
Yes, Lord.
Yes, item 6. This is against which order?
So, Malad, this MFA is.
Workman's compensation.
Yes, Because the order, an award dated 14 to
Just a moment. Employees Compensation Act. Employees Compensation Act, E. What is the substantial question of law here?
Basically, two substantial question of law. The number one is this one. The Commission of Workmen Compensation wrongly calculated allowance towards the salary.
But you'll have to amend it and bring it on record. The substantial question of law is not there.
Maybe taken up to day after I'll culture substantial.
No, it has to be made a part of the memo appeal. Look at subsection 3 of section 100.
Yes, my lord. That case it will take some time. Man.
Yes, you may incorporate it. Yeah,
Otherwise, if I
no, you do it.
file it
No, you
separately, man.
no. You give it here. We will permit you to change the pages.
Mine. Yes. I'll do it. I thought that it was already finished, man.
No. It may be elsewhere. I don't know, but under subsection 3 of section 100,
We have to find it.
Huh. it has to be made a part of record.
Yes.
Otherwise, on the prayer made by Mr. G. Boshel and counsel for the appellant, he is permitted to insert the substantial questions of law in the body of the memo appeal, which shall be done in the presence of AOJ, MFA, and Civil Appeal Section. Who would permit the learned counsel for the petitioner to insert the substantial question of law in the memo of appeal. And thereafter the matter be listed in the admission column again. You can do it tomorrow when you come. You just have to annex it.
As an NFA, madam.
No. In the body, you just add somewhere.
Yes.
It's a old matter. We can't,
This one.
what you call,
Due to response number 2, the matter was delayed.
no, whatever,
So- so we
2012 matter will not delay the matter by asking you to file an application. We are just permitting you to do it.
Declare.
But what are the questions of law? Let us hear it. Otherwise, if it is otherwise not admissible, we may not do that exercise.
That is already decided by this honorable court in a division bench.
Okay. Well, what is the issue?
Madam, towards calculating the salary, allowance cannot be added.
Allowance cannot be added.
Yes.
Daily allowance cannot be added.
Yes.
Okay. Item 10. Yes.
Against judgment and order dated 17/6/2023. Whereby my money suit was dismissed at the London trial court.
You are the plaintiff. Your money suit are dismissed. Okay. Mr. TR Sharma, learned counsel for the appellant. This regular first appeal. Order 41 rule 1, page 1 is directed against Wenzel. Second. Appeal is admitted for hearing, call for the records. The appellant shall take steps within 2 days for service of notice on the respondent by registered post daily, as well as by usual process. The notice is made returnable on 19 to 2023, list accordingly on the said date.
Apply.
11,
I want to take after some time. My senior is on next.
12. Well, somebody made a prayer for adjournment.
Lordship, Lordship, I will do this. Lordship, this is
Just a moment, just a moment. Yes, something I had to see.
file for modified judgment, Lordship, passed by the RCP, Railway Claims Tribunal.
Just a moment. No, but this is something we won't modify.
Yes, Lordship.
Correct, you take instructions because you see, we are, at times we are pained to understand that in these compensation cases, the money instead of going to the beneficiary is transmitted elsewhere. Correct. No, I'm not accusing you, but please understand, this is what the general perception is. In these claim petitions. And the second part is, that is why I wanted to interact with you. The second part is that the Delhi High Court had given an elaborate judgment stating the reasons why the amount should be broken up in fixed deposits and kept. And that order of the Delhi High Court has been accepted by the Supreme Court of India. And that has become a what you call set standard for all the courts dealing in compensation cases to have some amount of money locked in for a period of 3 to 5 years. So we will adjourn it, but this is something I wanted to interact. Next time be prepared on that. On the prayer made by Ms. J. Kalita, counsel for the appellant, the matter stands adjourned today. Ms. B. Sharma and CEC appearing for the respondent is present. List after
2 weeks.
after 2 weeks.
Okay.
13.
In education matter, 381 days, I don't hate my lord. Here are recent development taken place.
NCB, you are there?
One witness has been examined, my lord. So I pray, my lord, the informant has been examined, my lord, and inspected. So one witness, my lord, the informant examined already, my lord, by a trial court, my lord. So I pray, my lord, his statement maybe confirm, my lord. Perhaps it is not in the record, my lord. LCI has come, you know. Recently, he was examined.
Okay. And this is on which court?
He is, my lord, Amin Gaon.
Amin Gaon. Special Judge Amin Gaon. Mr.
MCT.
M. Chetia, Learned Counsel for the appellant, petitioner, submits that during the pendency of this application, the informant has been examined by the trial court. And he prays that the copy of the said statement be requisitioned. Miss
M. Deka.
M. Dekal, Learned Counsel for the respondent is present. Next, the registry shall call for the scanned copy of the evidence of PWs that has been recorded by the learned which court? Sessions. Sessions judge, Amingao, in connection with what is the case number? In connection with the NDPS case number 23 of 2023, arising out of NCV crime number 24 of 2022. Next, the registry is permitted to send the requisition through email with liberty to the learned Sessions Judge Amingao to transmit the scanned copy of the record of examination of witnesses by email for being placed before the court. List on 12/1/2024. In the meanwhile, the petitioner is also granted liberty to obtain certified copy of the order to be placed before this court. It's on 12/1/2024. 11.
That is an order. There's a incident in this date is 98 of 22. I usually injunction date for the appellant was rejected. And the other party in this case,
You are the plaintiff.
finally played.
Your application for injunction was refused. Okay.
And the injunction or protection order claimed by the defendants.
Where is your prayer? Where is your prayer in the petition? Injunction application, where is the petition? Where is the?
Page 26. Then permanent injunction constraining the opposite party.
But where is the photograph of any construction going on?
There.
Because you see, the trial court has refused on the ground that they are in possession of the suit land. So they can't be restrained from entering into the suit land. So, what is the jurisdictional error in that order? If somebody is inside the suit land, how he can be restrained from entering into the suit land?
No, thing is that that was.
No, I understand. He's we'll accept it from you that he's a rank, what you call, outsider. He's a land grabber. He has grabbed your land. Unauthorized occupation. Everything is accepted. But still he is in occupation. How he can be restrained not to enter the land?
That is only on that land ground is rejected. But
No, because that was the elementary thing when we joined this LLB course. They said that the possession is 9 point of law.
this is my point of law.
But
No, but I had position because
My dad was also saying that.
No, but if you can show us that they are trying to carry out some construction, then we can protect you. You are under 30, order 39 rule 1, you are entitled to protection if they are changing the nature and character of this woodland.
My dad will not, by constructing the house will not, he has changed the character of the plan. And here, they are for protection was granted. And against that, you know, I have filed an appeal also. And this is titled as FAO 75 of 23. And that case is already issued, notice was issued, you know. On 11/1/2075.
Yeah, can I see that memo of appeal? Just.
And that matter speaks on 11/1. My prayer will be both the cases can be taken together. And their concern with the payment, AGFNF was that we have not purchased that in our by the same date. But because that was not the case.
Okay. On the prayer made by Mr. D. Chalia, Senior Counsel, assisted by Ms. M. Roy, Counsel for the appellant. List this matter on 11/1/2023 in the same court where FAO 75 of 2023 would be listed. Ready, go. Item 14. Okay.
The main problem are centralized out of.
Okay. Okay. On the prayer made by Mr. S. Das, the 11 counsel for the appellant. List after.
Immediately after the vacation.
List immediately after, list on 19/1/2024. Okay. 15.
It is a lordship. Lordship, this is an appeal filed to legal aid. My lord, court conferring judgment, lower court, the respondent has filed the suit
You,
for
you are the defendant.
defendant. Civil performance of contract is decreed before civil judge in order.
Okay.
However, when preferring the appeal before the district judge, the delay condonation application was not considered. Although there was a specific guideline from the Supreme Court, the corona guideline was there.
Shows that calculation. But the court has rejected it because of 1.5 years, I think. Delay, which is unexplained.
While the impugned district judge's order was passed on 10/11/22.
Uh, Oh, there's a condonation of delay application.
Yes.
Okay,
That was only rejected without going into the merits of the appeal. That was rejected.
oh, the delay is condoned.
Either
Okay. So in the appeal just shows the calculation, whether it
Under page 6,
is 6.
as the impugned order. 10/11/22.
10/11/22, yes.
My lord, the COVID extension period, which was granted by the, stated by the Supreme Court, my lord, it extended from 15/3/2020 to
15/3/2020,
to 28 February 2022.
28 February 2022. Yes.
So, my lord, if
So
that
from-
period is taken into consideration, my lord, the appeal was filed along only with a delay of, my lord, only 30 days.
It was filed when? June 22. So it will be 2 months.
But in the Supreme Court order, my lord, it was stated that if the limitation period expires within this.
No, no,
extended
before the first appellate court, if you go, you will get only 30 days.
30.
So we take it from 1/3/2022. 30 days would expire on 1/4/2022. Sorry, 31/3/2022. So you have filed sometime in June.
36/2022, it was filed.
36/2022.
Yes.
So it is clear 2 months delay. You'll have to explain. April, May, June, 3 months. 3 months delay.
My lord, if the,
Oh, no, not 3 months. 1/3/22 to 31/3. That means April, May, and June, 3 months.
in the order, it was specified, my lord, if the limitation period expires within the exempted period, then from 28 February 2022, this, again, the limitation, I will get the limitation.
Correct, that's what I'm saying. 30 days limitation. So 28 to take it 1st of March. 30 days is expires on 31st of March. So from 1st of April, you'll have to demonstrate. You have, from April to June is 3 months.
So, my lord, there was an explanation. We had filed the
Where is that?
petition was there, my lord. On page, my lord, 12.
Page 12. Page 12 is order 41. Where is the condonation application?
Condemnation application is page 8, I'm sorry,
8.
8.
But this is very vague. Could not file the appeal due to sickness. Because what is sick is again a disputed question.
My lord, the delay application in file before this court, I have annexed the medical documents. My lord, here.
Where is that?
Which has.
Page.
My lord, my lord, it takes away, my lord is pleased to take up the IA. My lord. On page 9 onwards, my lord, these are. Documents which say he was there with chest infection method. More specifically in page 20. My lord, in page 20 in the lower part, unspecified acute lower respiratory infection. Because of that, he was invalidated. He cannot take any hard work, cannot exert himself. As such, he was unable to approach the court and take the steps. Even otherwise, there is one more substantial question of law matters. The cross exam, handwriting expert has given an opinion in the case, but he was not cross-examined, but the finding was relied upon by the trial court in deciding issue number 4. A certain exhibit 3 matter, which is alleged to be fraudulent by me. That's not my signature. With my lord, turns to page 25 of the law judgment of the title suit matters. While deciding issue number 4, relevant part is page 27. May I read, madam?
I've read that.
Page 27.
I've read that last part.
Yes.
Continues spills to page 28. I've read that.
So that was relied upon, the opinion, without the expert being cross-examined.
Unfortunately, you have with you CPC.
Yeah.
You have. You read order 26 rule 10(2).
Report and depositions to be evidence in suit.
So report becomes evidence in suit.
Report of the commissioner and the evidence taken by him. But not the evidence without the report. Shall be evidence in the suit. There has to be an evidence with the report.
Now you see, it says the report of the commissioner and the evidence taken by him, but not the evidence without the report shall be evidence. So you see the question document report is a report, and that becomes an evidence. And next part says, but the court or with the permission of the court, any of the parties to the suit may examine the commissioner personally in open court, touching upon so and so. Therefore, you see, it is for the party who is disputing that report will have to make an application before the court for cross-examination. That is what I understand from this.
Yes, my lord, my humble submission, my lord, even if the party omits to do so, the court can.
No, because it becomes an evidence. You see, that's why we are showing it to you. 10(2) says report and depositions to be evidence. The report of the commissioner and the evidence taken by him. So you see, you have seen a question document. Question documents say that the document number so and so was sent by the court. These are marked as a Q1, Q2, and then the signatures are marked as there's another number D1, D2, or something. They are like that, and therefore the comparison is made. Comparative signatures would have been taken earlier. That goes to the record and then say that compared with the signatures marked as A1, A2, or they will give some number. And on comparison, they'll give a report. Correct. So that report is an encompassing report, which is also a report and also an evidence of this commissioner. So here it says it ends, first part ends there, semicolon. Second part says, but the court, with permission of the court, any of the parties may examine the commissioner personally. And here in your case, the court is writing that on February that report came. There's a date given in that page 27 you are showing us. The date is there. So on 28, page 28, the date is given. So in February it came until 11, that is till this October, November when the hearing took place, there was no application. And therefore it was not accepted. You find out something from this order 10 rule 2, because if that is evidence, that may not become a substantial question of law.
While I was going through for the document,
Yes.
IT.
I'll tell you. I'll tell you why. CRPC, Criminal Procedure Code. I'll show you why. This is CRPC 293-2.
The court may be things with someone and examine.
Yes, you see, in a criminal case, no proof is otherwise admissible because it's a duty of the prosecution to prove something beyond reasonable doubt. Therefore, even if the report comes, in a criminal case, you'll have to examine the witness to bring to a logical conclusion the report which he has given in food cases and all. This judgment you have cited before the court, it relates to a criminal prosecution where it says, and therefore the Supreme Court has rightly held that in a criminal case, evidence does not become a what you call the report of scientific expert does not become an evidence. Because otherwise, what would happen is, supposing that you have seen yesterday's news in what you call yesterday's news, I think, or day before yesterday, Pakistan. You have seen in TV. People are going to the court for filing their nomination papers. They are kidnapped from there, taken away. Their applications are not accepted, and a lot of political people are now inside just because they went to file. They belong to a particular team and went to file their nomination papers. So an expert sits there and says that no, this is defective. And I give a report of I am the scientific expert. I give an opinion that no, this signature is not of Mr. Barua. Mr. Barua is standing here and saying no, this is my signature. But I am an expert. I am saying that no, it's not a Mr. Barua signature. Arrest him, and then this evidence it becomes an evidence. Now, in a criminal case, can a doctored opinion at times opinions can be doctored. So, doctored opinion, can it become allowed to become an evidence by the court? Under the CRPC, it is no. Therefore, when you are citing me as judgment of CRPC interpreting criminal law, then scientific expert, no, it can't begin. But you see, I'm showing you 10-2. And that's why we are giving you an opportunity. You please develop. Because I have not come across any case laws on that point where this 10-2 has been interpreted that it is mandatory requirement. Well, let us test this theory in another way. You see, two people A and B are in court. A procures a scientific expert opinion report and gives it to the court. The B, who is a defendant, does not dispute that report. And the court suo motu says, no, call him and we'll examine him. The question is whether the court can suo motu in a civil proceedings, call a witness and examine. Otherwise, when it otherwise does not require that evidence for pronouncing a judgment. If the court finds for any reason that examination of some person is required for deciding the issue, then the court has ample power. If you don't find any other provision, 165 says so. Court may call anybody to come to court and then depose.
But in this issue, while deciding this issue, my lord, reliance has been placed on that.
Correct. If it is an evidence, why not?
But my lord, 10-2 says, my lord, the report of the commissioner and the evidence taken by.
That is evidence. I am shown you. I have told you the excerpts. I may be wrong because I don't. You see, question document report I will not remember verbatim, but I've given you a general idea of what it contains. That report itself is an evidence. He does not record a statement. The scientific expert will not call a man and then say, you are a cheater. Now you give me an evidence. I will ask you questions. Have you cheated? That you will find in that report that they have used this what you call what scope I forgot. There is a special microscope for examining that report, some kaleidoscope or something. I forgot the name, technical name. They will say that you used so and so. What you call grade 1, grade 2, or what you call the number of that machine, and they will say that examined from that and found that this is a pattern does not match. It will say the signature of so and so varies, it does not match from the question document. It does not give a report of the, it just says that the admitted signatures and the signature on board does not match. You correct me if I am wrong. If that is the ground, then there is no ground made up. Otherwise, if you can build up your case, we'll take it up on Friday. By that time, try to do some research, get us something more.
Other than that, the judgment is also, my lord, not based on the evidence. Evidence is merely hearsay. The amount of money has not been established, how much has been paid. It's for a specific performance of contract. But
no, the document itself says 1,50,000 or something received. 1 lakh or 1,50,000. There is some 1,10,000. The document itself contains that. Now, Mr. Barwa, just tell me one thing. You see, today morning, I came by a rickshaw to court. Just outside the court building, I deboarded the rickshaw and gave him 2 10 rupees notes as his fare. Correct. Now, many people have seen me paying him that money. But tomorrow, if I ask you as a witness that you have seen me paying money, you will say yes. And if I ask you the next question, how many notes were there? You will say, I don't know. Because you see, I don't display when I'm paying rickshaw fare, I don't display the 2 10 rupee note. Look, I'm paying him now. So I am not creating evidence. So you tell me, when somebody is making a payment of 1,10,000 rupees to a owner of the land, Tell me one person who has allowed somebody else to count money and then give it to him, and then he will say that, okay, now I've received it.
Interesting matter, that's the case.
No, I don't know. You see, this,
Money they do not know, but
they will say that, yes.
when one witness said, my lord, I have heard from the plaintiff.
No. You see, situation changes. Mr. Barua, we are interacting with you because you are legal aid counsel. Because for giving legal aid, since you are there, therefore we are asking you questions. Because you see, they deserve more. People who are getting legal aid will deserve something more. That is the question we are asking you. You see, let us say that this is something which somebody sold me, correct? Today morning, I needed a flag. I asked my court master, he bought me this flag. This flag costed 10 rupees. Now the shopkeeper is here. Shopkeeper says that, sir, this is 10 rupees. You gave me, your court master gave me only 9 rupees. So what is the remedy available? He can sue me for 1 rupee, or the transaction is void. Right title and interest passes away. If you have not been paid 1 lakh 10 rupees, at best you can come to court and say that we have signed in good faith 1 lakh 10. He has paid me 10, 1 lakh. So for 10,000, I claim my balance. So then we have to dismiss it, Mr. Barua. Because even this document of illness, you'll have to demonstrate something more. Illness is a vague term. There may be hundreds of lawyers in this court who are having so many problems, but still they are attending courts. And there may be some people who have little pain in the little finger, and they will not come to court.
I don't think he's having respiratory infection.
Huh?
He's having respiratory infection.
No, you see, there's a lower RTI. There's a lower respiratory tract infection, LRTI. What would be the extent of damage?
My infection method, he was working in some detergent factory. The gases he inhaled caused some problem in his lung. As such, which affects his mobility and everything.
No, if he's working, he'll have to show, he can show something more, that he was not attending the office, he was not doing his work, he was on leave during that period. If he's in service, he'll have more documents to show that he's not working. He can be fit to work. He can be fit to just meet a lawyer and sign it. Because Mr. Barua, in the civil appeal, perhaps in 1908, people had wisdom to think that clients may not be able to go to court, and therefore they say that first appeal can be drafted on grounds which will be certified by the lawyer. So please tell me, why does he have to go to a lawyer? We'll take it up on Friday. If you can't satisfy, then we are dismissing it. List on Friday, as paid for by Mr. K.R. Barua, counsel for the appellant. This citation you take back, because if you are referring to the citation, I'll have to deal with it. I have to make a comment that in a civil matter, you are producing a criminal procedure judgment, which perhaps you may not like it. I've given you back. Yes, next. 14. Oh, 16.
Appellant expired. Therefore, 4 is filed.
Is expired. Okay. Mr. S.P. Roy, counsel for the appellant, submits that as per his instructions, the appellant number. There are several, in fact, appellants.
Subhanchandra Nath hai. Appellant number.
So he appellant number one. Appellant number one has expired. And he seeks some time to take appropriate steps. You're there for all?
No, my lord, I am appearing for respondent number 1, 2, and legal years of respondent number 1.
Mr. T. Sek, counsel for respondent number one
And 2, my lord.
and two,
Substituted legal years of respondent number 1, my lord.
and substituted legal representatives of respondent number
1, my
one is present. So, matter stands adjourned today, list after
Sorry.
4 weeks.
highly obliged.
All right.
Seventeen. Yes, please speak loudly
Sir, hourly will appear. He is
after
in
some
a-
time. After some time.
Matter may be taken in a other date, because as per our instruction, matters might be settled between the parties. I
No, please tell us, because you see, when it comes to second appeal, I have to read something of it and come. So don't make me read. If you're taking time,
Other date.
another day.
I have a
Yes,
prayer,
yes.
because the order dated 29/9/2015, madam. The RSA, madam, was dismissed, madam. 8 years back, madam. And immediately after dismiss, the parties taken the brief from us, madam. And subsequently, madam, the appellant filed the arrestment petition. So, madam, the notice will be sent to the,
No, we can't do that. We can't do that. You have CPC with you. You have CPC. তাতে রাখো আপনাদের।
the brief has taken back.
No, but we can't help it, because for the purpose of order 3, you continue to hold the brief. We can't spend government money to court funds to give notices on your behalf. You are under order 3, you continue to be the lawyer.
Then madam, the next date may be given.
No. You see, the CPC for the purpose of Rule 4, restoration application, you continue to be the lawyer. Both sides are duly represented on the prayer made by Mr. T. Sek, counsel for the appellant. Matter stands adjourned today. List on 8/4/2024. Sorry, 8/1/2024. Yes, 18. Yes, Mr. Mohand.
As per earlier ordered, we have taken steps on the sole respondent. For service report, return and official 12/12, so that sole respondent expired. So therefore, I pray for police and file appropriate applications.
Okay, Mr. A. Barwal, counsel for the appellant, submits that he has seen the office note dated 12/12/2023, indicating that as per Professor Server's report, the sole respondent has expired. So he prays for some time to take instructions and to take appropriate steps. Matter stands adjourned today, list after 4 weeks.
Obliged.
This is item 19. Yes,
This case, because I have filed an affidavit today, madam, but I have lost contact with the client, madam. So I have sent the note, I have filed an affidavit today, madam.
for
But in this case, I have lost the contact with the client, my lord. Thereafter, I have sent the notices to them, but there is no response from them.
Something is wrong here. Two. But you see, we'll have to, even if you have lot of gross contact, the prayer for amendment, it cannot be allowed. You are, the nature of prayer you are seeking is to bring relief against the proforma, what you call the dependent numbers 1, 2, and 3, which will be otherwise. Where is the plaint?
14, man. 1, 4, 14. There are miscases, my lord, some of the respondents expired.
You see, the main prayer here is that for cancellation of that mutation.
Page 20.
Yes. Mutation, I have my own doubt whether the civil court can pass an order to cancel mutation. It, no, I don't know, because otherwise, if you get right title interest, it will be a precept which is issued to the authorities. But if you send if you ask for a declaration, that is hit by section 154. So this order can't be passed. And then second is the order of mutation if you are challenging. It's a suit of 2002. There is a mistake in your synopsis about the date. You said it was filed on 2000. 2004. Suit is of 2002. And if you are seeking amendment in 2004, the cause of action is of 80, is of, you see it page 22, last cause of action is of 1992. It will be barred by limitation. If you are now seeking any relief against the defendant by way of an amendment,
The trial court has found that the suit is not barred by the limitation.
no, but you have to still explain, because now we are looking at the, because we are now examining it as a jurisdictional error.
There's only the amendment part dependent. There are two petitions, my lord, one filed by the defendant for 4. And the basis of that petition, my lord, to renew the issues were framed. And my lord, the plaintiff has also filed one petition for amendment. Both the petitions were rejected, so basically this revision petition is against the amendment.
No, you are agreeing on the amendment application. So in amendment application, why it can be allowed? It can't be allowed. Because the cause of action doesn't change. Now, if you are asking any relief today, by way of an amendment, that amendment in a plaint will relate back to the date of the suit. So time barred relief would be granted. You see, an amendment makes, is always related back to the date of filing of the suit. So how can I, when on the date when the application is made, on that day, the prayer would be barred by limitation. So how can we, by permitting an amendment, create a cause of action for you in a back date?
Number of amendments that's also had.
There's only one point, if you can show, we'll take it up on Friday. You can show us on the point of limitation, whether the code by way of an amendment can permit you to amend the plaint and introduce a relief against a person, because on the day when it is allowed, it will be barred by limitation. We'll allow your amendment, relate you back to relief, which is of cause of action is of 2002. Today we are in 23. Friday. Let's say the, sorry, Mr. A.K. Gupta, counsel for the petitioner, sorry, petitioner, and Mr. T. Agarwal, and T.R. Gogoi, government advocate for the state are present. On by counsel for the petitioner list on Friday. 5. 21.
There is an order, my lord. Court level.
Why it has come for orders?
There is an order, my lord, of this honorable court, my lord. 11/10/2023. That particular date, my lord, this honorable court has ordered that I have not served the copy to the respondent number, copy to the opposite party. And I have served my copy. The copy, and my lord, the application is not available, my lord, in the record. I have found that my lord, application is found in the record. And my lord, so far the process, sir, report is concerned, my lord, it is marked as flex X, my lord. Is served. On the respondent number 2A, legal representative of respondent number 2, my lord, who died, my lord.
Mr. T.V. Laskar, counsel for the appellant, has referred to the process service report. Dated 4/4/2023. Indicating that notice was served on the substituted respondent number 2 within bracket A. Post. Accordingly, notice on the substituted respondent number 2 is accepted to be duly served. None appears on call for the substituted respondent number 2A. Ms. S. Chakravarti,
Three separate.
A. Chakravarti, counsel for the respondent. Number
1, 3
1,
to 5.
3,
1 and 3 to 5.
1 and 3 to 5 is present. First off, she has been served with a copy of the substitution application. He says so. If you're not gone, you can take it from him. As per the office note dated 5/12/2023, no application has been received by the section till date. So accordingly, the land counsel for the petitioner shall inform the AOJ civil appeal section of the proof of filing of their application.
That application, so far the application IA number 523 is confirmed and it's available on the record. It is available on the record.
It is available.
What's it?
Which one?
First one, I think, first one. Within this cover. Within the first 5 minutes, within this cover.
That's one number 2.
2A. The application number 975 of 2018. This is the.
But then it's already allowed. Why this
Yes.
matter has been pending again then for that application? Why or no notice?
Already disposed of.
No, but you see, you are allowing court to pass orders which are inconsistent.
So that I have not filed this.
No, you see, when the court was passing an order, that takes steps upon legal representative of respondent number 2. The application was allowed in 2019. You can stop it there. That notice it into is reserved on a person call for soon. As the LCR is received, this is the matter for hearing in the month of February 2024.
Like-
Give her a copy if she is not received.
Like-
Okay.
2020, skip question, sir.
Okay, item 20. I missed out.
The
Yes.
appeal is covered by decision of this honorable court in an analogous case.
This was dismissed and restored.
It is dismissed and restored.
Okay,
And so for merit of the case, my lord, your lordship, I am just submitting a decision of this honorable court, which is in regard to analogous case. The matter was, the vehicle was under requisition.
just a moment. This was the car which was requisitioned by the state.
Yes, yes.
Okay. Yes, you have to make a step, Mr. Gogoi. For the government. You are responsible for 4 and 5. There's a motor vehicle accident, at the time of accident, the motor vehicle was requisitioned by the state. But during at the time of this acquisition by the state, does the policy stop, what you call, its efficacy is stopped by any order?
The SUD. The moment it is requisition, the registered owner has no responsibility. It goes to the state.
No.
The decision, my lord,
No, that is okay. You have shown us that. But what happens to the insurance policy?
yeah, but insurance company will not be liable. So the registered owner is not liable in that. The moment registered owner is not liable, the policy will be on board. But people find that in, the decision of.
National Insurance Company was the Deepa Devi.
One.
Yes, madam, we'll take a call. We'll take it up on Monday. Take instructions on the matter. Monday will be out of station. We're fixing it on Friday then, next Friday, 12th. You take note of the citation. Next time be prepared. Please give in the citation. This National Insurance Company was a Deepa Devi, DEEPA, Devi. Citation, what is that citation? Give it to him.
2018 one SCC.
Write it down. Write it down. We are returning you back this. Chances of being misplaced was there. Mr. S. Datta, Senior Counsel, assisted by Ms. M. Chaudhary, Counsel for the appellant, as well as Mr. T. Chakravarti, Counsel for Respondent number 1, and Ms. C. Mehdi, Counsel for Respondent number 3, as well as Mr. T. R. Gogoi, Learned Government Advocate, appearing for Respondent numbers 4 and 5. As per on the prayer made by Learned Government Advocate, the matter stands adjourned today. List on 12/1/2024. Okay.
Yeah, some.
Okay, the registry shall reflect the name of GA Assam in the cause list by listing the matter next. If you don't have the documents, you can ask Ms. Chaudhary to give you photocopies. Get it xeroxed at your office and return it back to her. Correct? This is item 2223.
Item 22 with 23.
Yes, what has happened in this matter? Okay, please don't call for the appellants. However, Miss SS Bora, the counsel for the respondent is present. As the case is ready as regards service and LCR is received, let the matter be listed for hearing in the month of February 2024.
Twenty-four.
Without classes. Yes, right has come.
I've got a respond number 125. As per office note dated 18/12/23.
Service is complete.
Service is complete. As per respond number 6 and 7.
LCR has come.
Yes.
Okay, both sides are represented. Case is ready as regards service and LCR is also received. So accordingly, list the matter for hearing in the month of February 2024. Okay. 25, 26. Yes. Yes. You have not filed your Wakalatama?
All the claimants I am very all the claimants lordship. Lordship, I think the MSCFL 36818 is.
Just one by one. There are 2-3 matters connected. I'll take up one by one. So notice has to go to others. Oh, okay. Just a moment.
I have to receive copy load, so I will receive that.
You're not in speaking terms with her.
I have not received since
No, no, not received is, if she will not go to your home and give it to her, you can just call her and you could have told her, you are sitting together. You could have asked her to give a copy. Give me copy, this is the order which I am not passing. If you have, you can tell, otherwise you file an application saying that you have no talking terms and then therefore.
I simply
Request her and then she'll give it to me. I am not passing any orders, give copies. Padmi Sain Chaudhary, counsel for the appellant, and Mr. A.R. Agarwala, counsel for respondent number 1. Next para. The non-counsel for respondent number 1 has submitted that he's filed Vakalatma only for the respondent number 1 claimant and is not holding the brief for respondent numbers 2 to 9. Accordingly, let a notice be issued on respondents number 2 to 9, returnable on so and so. Who has appeared? Yes, this is 816. And what about others? 3 to steps you'll have to take. You see, so only 2 has appeared. Not 2, not 2, 3 to so and so. Before that, you say none appears on call for respondent number 2. Notices takes steps within 2 days. Notice is made returnable on so and so. The counsel for the applicant is postal receipt and track report. That is 81. This is MSc appeal 816. Then what is this? IA civil 3254. What is the ground of?
And Lanet Settlement observed the evidence when there are 2 vehicles are involved and accordingly, then both the insurance companies liable for both the insurance companies made liable for the compensation mostly. But the main, we have agreed by the point of view, can you page number 10?
Page number?
10. Internet is 10 and 21 there, 1 is the claim.
Page 10, yes. Internal page 10 is something passed in review application.
21.
21. 21, yes. ₹3 lakh. 28,000.
All the claimant is alleged entire amount of funds granted from one of the insured if we receive an account paying check. So our vision is that also the apportionment is not here now.
Why?
It's not clear.
Why?
Because we are not on that we are not liable. Both the vehicles are made liable. Only apportionment is not there. So on this remand the matter on the.
No, remand is something I'm not doing it mechanically. You have to show us why I can't, why this court can't make that apportionment, why should I send it back?
What function is there? India, what must they, how much he has to, India insurance company has to pay and the other definitely should. That apportionment of the award is not.
No, why 50% is wrong?
We are not saying that wrong. This is not, we are ready to make it. Both the parties are ready. That apportionment is not there, since there is no apportionment. Only for that, we are before your.
No, then it can be disposed of. Why we send it back? We say 50% and end of the matter. Where is the other insurance company? Who is appearing for the other insurance?
Service was not there. And it has come after 1 year. The matters come after. So we'll take steps and.
You see, instead of filing this appeal, you could have just spoken to the other manager and agreed to a 50% and then end of the matter.
At this stage, I am request that let them deposit 50%.
You deposit 50% in the meanwhile. You pay because you see, he has suffered, he is the claimant, he has suffered. You pay 50% in the meanwhile. We'll issue notice because otherwise you will have to, you see, otherwise I will not grant a stay. For that you will have to deposit 50%. Correct. Who's the other insurance? National insurance. Who's appearing for national insurance normally? No, who appears normally? Who appears?
Mr. R. Goswami.
Mr. R. Goswami. Okay. And Mr. Sharma is not there. Mr. A.J. Sharma is not appearing for that insurance. No. National insurance, you are not appearing. You are appearing. Huh? No, it's okay. We'll ask him. Can you communicate with them and then say it? Because otherwise, this is a case where she says that 3,28,000 was the award amount. The MSCT court forgot to say 50% each. So therefore, you see, this order, if it is executed against you, you can be made liable for the entire 3,28 because the court order says that it can be claimed from one and shared between the two. Correct. So we ask you to take instructions. Instead of issuing a notice on we are issuing notice on them, but we are also requesting you, since you are present, we are requesting you to take instructions. Epilogue. Give a copy. Next para. Notwithstanding that notice has been issued on the respondent number 9, i.e. National Insurance Company Limited, but the court has noticed the presence of Mr. A.J. Saikia Leonard, counsel who also represents National Insurance Company Limited in several matters, and therefore the court has requested the said Leonard counsel to obtain instructions in this matter. Next para, it is made to appear to the court that the learned member, Motor Accident Claims Tribunal, Dhubri, while awarding a sum of rupees 3,28,600 to the respondent one claimant, directed that the payment be made jointly and severally by Oriental Insurance Company Limited, as well as the National Insurance Company Limited. Oh, okay, New India. New India Insurance Company Limited. You are not appearing for New India. Yeah, that's New India, not National. New India. Respondent number 4. Respondent number 4. Full stop. Therefore, it is projected that the appeal is filed only for the purpose of apportionment of share of the two insurance companies. Full stop. In view of the nature of challenge made before this court, the court has requested the learned Mr. A.J. Sekhar and counsel to obtain instructions. Full stop. Faculty are the first answer. So from the said or from the order implemented in this appeal, it appears that the claimant is also given liberty to collect the compensation amount from one insurance, and there can be inter se apportionment between the two. So therefore, as the Learned Counsel for the appellant seeks apportionment of the award between the two insurance companies, the court deems it appropriate that Mr. A.J. Sekhar and counsel be requested to obtain instructions as to whether they are agreeable to share the compensation amount equally. Next, let a copy of the memo appeal be also served on the Learned but to Mr. A.J. Sekhar and counsel, enable him to obtain instructions. It will be an appeal, huh? The stay application. That's and so. The issue notice on this application returnable on same day, on so and so. The limited extent of challenge in the connected appeal is reflected in the order passed today in the connected MAC appeal 816 of 2018, which is not reiterated herein. Next para. Having regard to the nature of grievance raised by the applicant, the court is inclined to stay the operation of the impugned award judgment and award dated 3/10/2017, passed by the learned member MACT Dhubri in MAC case number 211 of 2014, subject to deposit of 50% of the awarded sum with interest thereon for the registry of the court within a period of 4 weeks. 6 weeks, 6 weeks from today.
So claimant may kindly without.
Let the deposit, we will pass an order. Okay. No, you don't need to pass an order. Just tell us. We are keeping it pending. We are not disposing it off.
50%.
No, I understand, but let her deposit first.
Once I deposit,
You see, there are ifs and buts. We know what happens in the courtroom, correct? We are giving a fixed date for appearance. Notice is fixed date, so there is no issue then. Next, the Learned Counsel for the respondent number 1 is permitted to renew the prayer for release of the money to the respondent number 1 claimant on the next date of listing. Next, it is also made clear that the only issue between the applicant and the respondent number 4 is the apportionment of the award. So therefore, the Mr. A.J. Sekhar, counsel for respondent number 4, shall also obtain instructions as to whether the respondent number 4 would be ready and willing to deposit 50% of their share of the awarded sum before the court within the next returnable date. Next, the Learned Counsel, Mr. A.J. Sekhar, Learned Counsel, is permitted to send a downloaded copy of this order to the respondent number 4 to bring the order to the notice of the said authorities. List on, give a fixed date,
19-2.
19/2/20. Yeah. Then there are other applications. What is that? CO, what is cross objection?
I filed for enhancement, Lordship.
You're pressing that? Cross objection is within time?
Yes.
Huh?
Give the copy. I've given the.
What is the cross objection? Now you've seen. Mr. Agarwala, what you throw up comes back. Again, same thing, copy not received. So what you throw up will come back.
Yes. That is the main.
Unless you are throwing out a Chandrayaan.
Yes. Now another Yan is.
Correct. Give us copies.
Okay.
Heard Mr. A.R. Agarwala, counsel for the applicant, and Mr. M. Chaudhary, counsel for respondent number 1. Issue notice on this cross objection returnable on same day. The applicant shall take steps within 2 days for service of notice on the respondent numbers 2 to 8. No, notice will go to 2 to 9 also. 2 to 9 returnable. Steps on 2 to 9 by registered postal DD. Postal receipt number, track report. List on so and so. No, you take steps. Because you don't know what comes up.
This ABC appeal number 368.
368, what is that?
That is, I think wrongly tagged to this appeal Lordship. Because they belong to defined accident Lordship. This is totally different meter Lordship.
That's fine. There must be some order, it doesn't go tag, get tagged in. Just like that.
In the 816.
No, first case of appeal go.
Order dated 16/12/22 Lordship. Order is there.
368.
Yes, Lordship.
No. Here it says list the matter on receipt or records along with MSC 368 of 18. Why? Different matter.
That is mistake of fact. Mistake of fact.
No. It doesn't. You see, then who is appearing for respondent number 2 in this case? You said somebody appeared. His name is not there. Huh? No, but his name is not there. When you said respondent number 2, I was reading Mr. A. Dhanuka here in item 26, not that. So what is the name? Faizul Haq. After MSc appeal 816, item 25. That's you. The Land Council for the appellant submits that Mr. Faizul Haq, Land Council, has entered appearance for respondent number 2. So accordingly, the registry shall verify and in the connected condemnation application. 32 being IA Civil 3253 of 2018. So the registry shall verify and reflect the name of the said learned counsel for respondent 2 while listing the matter next. I took for Java. Service then 816. In MSc 816, you also write an order. The learned counsel for the appellant has referred to order dated 16/12/2022 and has submitted that this matter is not related to MSc appeal 368 of 2018. And accordingly, she prays to detect the said records. The prayer is allowed that the records of MSc Appeal 368 of 2018 be listed separately. And then this also you write. And 26, who is appearing for the appellant, National Insurance? Nobody is there. None appears on call for the appellant. Or the respondent number 2. In view of order passed today in MSc Appeal 816 of 2018, list this appeal independently on 8/1/2024. Okay.
Lordship, this 816 belongs to us. Lordship.
Item number 25.
25.
I know where.
That is given 19 to
19.
No, you see, don't make two submissions. You are saying that this is not connected with 386.
Yes, Lordship.
Then now when I'm posting this on Monday, you are saying that the earlier case is on that day. What is your intention?
Lordship, this 368 has to be detected.
I have done it. What you have not been hearing us. But you see, I don't shout and pass an order, but when I'm passing an order with I'm on mic, you please hear us. Correct. I'm taking so much of time. Why? Because I have to make the orders right. Why I'm spending so much of time? Don't disturb without understanding. What have been hearing? Please tell us what order you were hearing when I was dictating. What did you hear? No, please don't disturb. When the order is not wrong, please don't disturb. Reserve your argument when it is come to substantive argument. But if you don't hear and start telling us what to do, it's not appropriate. If you would have heard us and then found out a mistake, then I understand. But if you don't hear us and then find a mistake. Item 28 or 27. Yes.
May I please your lordship? My lord,
Just
I
a
want,
moment. Just a moment. Yes.
I want to file written objection on behalf of respondent.
Okay. How much time?
After 2 weeks,
After 2 weeks. Okay. Mr. M. Adi, counsel for the appellant is present. Miss
M. Khatun.
M.
M. Khatun.
Thakur.
Khatun.
Khatun,
Khatun.
learned counsel for the respondent. Prays for and granted 2 weeks time to file written objection in the matter. This chapter and saying, make it on 19 January 2020. Okay. Okay. Yes, 28. Stomato. This was something, who is appearing for the Who's appearing for respondent number three?
Appeared till now, but this Sunday might have assessed the High Court, the registry, the advocate, the judges, my lord, who is my lord, office beyond, in an official notice. The logic can see, but it was not accepted by the registration. Because this nothing on found.
Can you show us that?
I have to open it up, because you know, more, as if my is the instruction from the court. मुझे वाले गाड़ी का because सात साइज गाड़ी गाड़ी का
No, take it, we'll have this opened. You've seen that? You've seen that?
Yes.
If you have it open, give it to me. Because
It has been given the file.
this, what do you call this? Mr. Nath?
Yes.
With regard to that observation, do you have any objection to that expunging of that?
I'm not opposing that.
You're not opposing that. You're appearing for? Who is responsible for?
State legal service.
Or legal service? You have any objection to that? No. We are expunging it and we'll take it up on the administrative side.
But that's yeah.
Heard Mr. T.J. Mahanta, learned senior counsel and learned standing counsel for this court, assisted by Mr. A. Barua, learned instructing counsel. Also heard Mr. D. Nath, learned senior government advocate,
For the respondent number one.
appearing for respondent number one, along with Mr. Singh, I forgot your first name.
Yes.
Mr. J. Singh, learned government advocate. Also heard Miss G. Das, learned standing counsel for the State Legal Services Authority, respondent number 4. Next para. There is no representation from the respondent number 3, on whom notice was issued. Next para. The next para. It has been brought to the notice of the court that instead of entering appearance, the respondent number 3 has sent a communication to the court through the deputy registrar within bracket judicial JUDL dash Roman 5. The same has been opened. And the communication has been perused. Full stop. It appears from the contents of the seal cover marked confidential by the respondent 3 that it contains a letter number capital CJ symbol and capital ASJ oblique 2023 oblique JUD oblique 331 oblique capital G dated 8/11/2023. It contains the reply on behalf of respondent numbers 2 and 3. So respondent 2 is the office of the respondent 2 is the assistant session judge Dhubri, and respondent 3 is the judicial officer who is posted as the civil judge within bracket senior division bracket close and assistant session judge Dhubri. Full stop. The said letter is addressed to the Registrar General of the court. Full stop. The said letter dated 8/11/2023, not being in the proper format of an affidavit in opposition, the said communication dated 8/11/2023 is outrightly rejected, being not admissible as the same is not in the proper form. Therefore, no cognizance of the contents of the said letter dated 8/11/2023 is taken. Next paragraph. This suo motu CRP has been registered on the basis of and communication registered on the basis of note put up by the registrar within bracket judicial, on the basis of a letter number, pink flag, and number BLSA oblique capital DBV oblique SECY capital oblique 2014 oblique 1194-95 dated 3/8/2023. Whereby the District Legal Services Authority had referred to the critical observations made against the said officer by the learned assistant sessions judge within bracket respondent number 2 and 3 in the order dated 5/4/2023, 5/4/2023, passed in sessions case number 36 of 2022. So the observations which is projected to be detrimental to the career of the concerned District Legal Services Authority, Dhubri, which is contained in the order dated 5/4/2023, is extracted herein below. We right from page 13 to 14, that underlined portion, page 13, 14. Yeah, after this flag, after this flag, page 13, 14, underlined portion. Next paragraph. From the contents of the said communication dated 3/8/2023 by the District Legal Services Authority, Dhubri, it is noted that the said authority had received a list of UTPs dated 26/8/2022 from the Inspector General of Police, Guwahati, dated, no, his date is already there, wherein the name of an accused in Golagganj PS case number 836 of 2020, corresponding to Sessions case number 36 of 2022, for offense committed under section 120 capital B IPC, read with section 6/12 of Passport Act, read with section 14 of the Foreigners Act, was found languishing in jail. Although jail for non-furnishing of bail bond / sureties, although bail was granted to him. Full stop. Moreover, it appears that the Assam State Legal Services Authority, by letter dated 26/8/2022, bearing number ASLSA -114/2010 part PT Roman 1/768, had requested the District Legal Services Authority, Dhubri, for filing petitions for modifying of the alteration of bail conditions in respect of the UTPs whose name contained in the list, which was pursuant to directions issued in WBC number 8 of 2018, the WPC within bracket Suomoto, number 8 of 2018, passed by this court. Moreover, an application was also received from the superintendent, district jail Dhuri, wide letter number capital DJD, 18, public 2019, public capital UTP, public 1, public 1377, dated 4/9/2022, requesting the District Legal Services Authority Dhuri to release the UTPs whose name appear in the list sent by the Inspector General of Police, who were granted bail but still languishing in jail for non-furnishing of bail bond public securities. It appears that there were several communications between the Assam State Legal Services Authority and the Legal Services Authority, Dhubri, with regard to the release of under trial prisoners who were granted bail but were languishing in jail for non-furnishing of bail bonds. So it would suffice to mention the to mention that not that as there are several communications, the court is not burdening this order with the details of communication made between the two authorities. So it would suffice to mention that by a letter dated 18/2/2023, the Assam State Legal Services Authority had requested the District Legal Services Authority, Dhubri, to go through the judgment dated 31/10/2023, passed by the Supreme Court of India in Suomoto WP within bracket criminal bracket close number 4 of 2021. And this District Legal Services Authority, Dhubri, was asked to follow the guidelines contained in the said judgment. Full stop. Accordingly, the District Legal Services Authority, in order to comply with the directions contained in clause 4 of the order of the Supreme Court of India dated 31/10/2023, referred above, sought for socio-economic conditions of the UTPs who had been bailed out but not released. And the said communication was made to all courts to relax the conditions of bail public security by data dated 28/3/2023. Next para. The respondent number 2 and 3, by a letter dated 31/3/2023, directed the District Legal Services Authority, Dhubri, to produce before him the details regarding materials relied by the said authority, and to explain as to why and on what basis the letter dated 28/3/2023 was submitted. And direction was also issued, so submit a report within 7 days. Full stop. The District Legal Services Authority, Dhubri, by letter dated 4/4/2023, submitted a report before the learned, before the respondent number 2 and 3 regarding non-release of the UTP of Sessions Case number 36 of 2022, who was bailed out but not released due to non-furnishing of bail bond. Full stop. On receipt of the said reply, the respondent number 2 and 3 had passed an order dated 5/4/2023 in connection with Sessions Case number 36 of 2022, and the remarks against the District Legal Services Authority, Dhuri, was passed, which is extracted herein, above. Next paragraph. The learned standing counsel for this court, the senior counsel and standing counsel for this court, upon instructions, has submitted that the district legal, that as per his opinion, the District Legal Services Authority, Dhubri, was doing its duty and was complying with the orders of the Supreme Court of India passed in suo motu WP within bracket criminal CRL number 4 of 2021, wherein which contained a direction that the Secretary, the District Legal Services Authority would find out the socio-economic condition, economic condition of the accused with the help of probation officers or paralegal volunteers to prepare a report on socio-economic conditions of the inmates to be placed before the concerned court with a request to relax the condition within bracket S conditions of bail/security. Full stop. The this is a reported judgment, I believe. This suo motu criminal, that is a reported judgment. No, I understand, but these orders are reported. I'm just asking if you are aware of that. Because giving citation is easier than to write so and so dated, so and so everything. No, I'll just get it. If it is there, we'll get it.
31, 126.
Next para. The the next para, the learned senior standing learned senior counsel and standing counsel for the court has brought to the notice of the court that this that the Supreme Court of India has registered a suo motu WP within bracket criminal number 4 of 2021 under the caption in re semicolon policy strategy for grant of bail. And various orders are passed therein from time to time. And that by an order dated 14/9/2022, the Supreme, which is reported in within bracket 2022 bracket closed 0 Supreme within bracket SC bracket closed 1746 has also passed an order directing the registrars of each High Court to depute a nodal officer of the rank of the registrar in each of the courts to carry out the monitoring of the same. Hence, it is submitted that that as per paragraph 7 of the said order, as per para 10 of the order, it was expressed by the Supreme Court of India that all the state governments were to fully cooperate, as the crowding of the jail is a problem permitting PERMEATING the country as a whole, more or less. And certain suggestions were made. It has also been pointed out that by another order of in the same suo motu writ petition dated 31/1/2023, the Supreme Court of India had observed that the NALSA, NALSA, within bracket, National Legal Services Authority, bracket is in the process of creating a master data of all such under trial prisoners in Excel sheet, EXCL Excel sheet, with all relevant details, including reasons for non-release and steps qua QUA, qua persons who are unable to furnish bail bonds or surety, having taken up with the respective state legal services authorities and the district legal services authorities. And it was expected that results would be obtainable in about 1 or 2 months' time. Hence, it is submitted that the District Legal Services Authority, Dhubri, had taken steps in accordance with the directions contained by the containing the orders passed by the Supreme Court of India from time to time, and also in view of various communications received from the State Legal Services Authority, Assam. Next para. The learned senior government advocate appearing for the state of Assam has also submitted that the state government is taking the matter in the right earnest, and reports have been submitted from time to time to the various authorities in this regard. Moreover, as the District Legal Services Authority is an office which is vested, whose control is vested on the state government, he has no objection as to the expunging of the remarks made against the District Legal Services Authority, Dhubri. Similar view has been expressed by the Legal Learned Standing Council for response number 4. Next para. Having regard to the various directions contained in the orders passed from time to time by the Supreme Court of India in the proceedings of Suomoto WP within bracket criminal number 4 of 2021, and having regard to the contents of the communication made by the District Legal Services Authority, Dhubri, to the Assistant Session Judge Dhubri, which is the position which is held by the respondent number 3. The court is of the considered opinion that the adverse remarks appearing against the District Legal Services Authority in the order dated 5/4/2022, 23, passed by the learned Assistant Session Judge Dhubri in connection with Sessions Case number 36 of 2022 stands expunged forthwith. Next para. Having noted that the learned assistant sessions judge Dhubri had overstepped his authority to question the District Legal Services Authority on the communications made by him, the court is of the considered opinion that this is a fit case for the conduct of the respondent number 3 to be examined by the registry of the court at an appropriate level, and the matter be also placed before the concerned portfolio judge of the district of Dhubri to bring this order to this notice of this to the honorable portfolio judge. And thereafter purposes for appropriate for his lordship's perusal and doing the needful. Next para. The court takes notice of the fact that the District Legal Services Authority, Dhubri, is also a member of the Assam Judicial Service. And there may be a possibility of the concerned officer be working directly under the control of administrative control of the respondent number 3. So therefore, the respondent number 3 is put to notice not to not to harass the District Legal Services Authority, Dhubri, or take any stern measure against the said officer without prior approval of the registry of this court. First of all, this direction is being issued to protect the officer from to protect the District Legal Service Authority. The officer presently holding the office of District Legal Service Authority, Dhubri, from the respondent number 3. First of all, next, therefore, the registry shall communicate a copy of this order to the respondent number 3 to bring the order to the notice of the said officer. Next paragraph. This revision stands allowed to the extent as indicated above with it could be good. Anything I have missed out? No.
The police have to take the.
Police. Oh, it's okay, yes. You take back this. Yes, I'll give it back. Anything you could recollect I have missed out? Yes. Any item? 30. Yes. This was dismissed. Item 30. Just a moment. This is item 29. What is this? Item 29. Anybody is there?
29.
Yes.
Please come up for it.
Notice is served. Respondent has appeared.
$29.
29. Okay. Oh, Mr. Datta, you are there. It will come up for admission now.
No, I am not. I'm in item 29.
29 are called. I'm coming at 29.
Can you lordship fix a date in the?
Yes, I'll fix it. No, both sides are represented. Due to positive time, matter could not be taken up today. So the case is ready as regards service. List the matter on so and so in the admission column.
Right.
29. 30, yes. No, they will not send because of the order of the court. But why we delayed it? What is the explanation, Mr. Das? What is the explanation? No, but on the last date you were there. The order was passed in your presence for taking steps. Then what is your explanation for not taking steps? No, don't blame your clerk. We don't adjudicate on the steps taken by a clerk. No, Mr. Das, you see, I was also there where you are standing. My clerk will always say whatever I say. He'll sing my music. If I ask him to come here and say, he will say whatever I have said. Correct. Then, no, always take responsibility. Don't throw it on that. Okay. Mr. B.K. Das, counsel for the applicant. Submits that there was an inadvertent delay in taking steps. Full stop. Instead of taking steps within 5/12/2023, steps was submitted only on 8/12/2023. Full stop. He has expressed regret for not taking steps on time. Full stop. Accordingly, the delay stands condoned. Full stop. The registry shall now issue the process on respondent number. Also on the sole respondent. First of the notice is made returnable on 19/2/2023. So the registry shall process the steps already available on record. First of the learned counsel for the applicant shall ensure that adequate postal stamps and other requisites have been filed. List on 19/2/2024. 31.
31.
It's a second appeal, there is a delay condonation.
64 days. You are seriously opposing it?
But my name is not coming.
No, it's okay. Your name is already viral. You are online. None appears on call for the applicant. How Mr. P.K. Royzuddin, counsel for the respondent, is present. First of all, Angel receives the matter stand adjourned today. List on 8/1/2024. I think I'll have to wind up for the day. Yes. 53. Oh, okay. Wherever there are interim order, please tell the court master, we'll pass orders. Other matters will be rolled over.
I am here.
Hmm?
So, item number 53, and I have no objection in allowing the petition so far as the case.
53 is transfer application.
Yes.
Supplementary cause list. Oh, 53. Okay. Okay. Mr. A. Cabra, counsel for the petitioner. as well as Mr. O. Laskar, counsel for the respondent is present. Next, this transfer application. What is the case?
Divorce case.
Okay. This application under section 24, CPC has been filed for transfer of matrimonial proceeding being so-and-so divorce from so-and-so to so-and-so. Next para, upon instructions, the learned counsel for the respondent has submitted that he has no objection to the transfer of the proceedings. To stop. Such submission being made, the application stands allowed. The proceedings of so-and-so stands transferred from so-and-so to so-and-so. Next para. As both sides are duly represented, they would appear before the learned transferee court on 2/2/2024. Next para. In the meanwhile, the learned counsel for the petitioner shall produce a certified copy of this order before the transferor court. At which place? Transferor court is at?
Here.
At Guwahati. So Guwahati. So as to enable the said learned court to transfer the records of so-and-so to the court of? No, from family court to where?
District court, from district court, Karimganj.
From district court, Karimganj to here, from the court of district judge, Karimganj to family court. Family court, Kanpur Metro, Guwahati, to stop. On receipt or record, it would be permissible for the principal judge, family court 1, Kanpur Metro, Guwahati, to transfer the record to any of the 3 family courts at Guwahati. In the presence of parties, i.e. on 2/24 or any other subsequent date.
It may be given for.
I've given a date, 2nd of February. On 2nd of February, you appear. If the trial records do not go there, then they will fix another date and you appear on that date. Correct?
Fine.
But you will have to give a certified copy before the Karimganj court. Otherwise, this transferable order will not be effective. Okay. 33 disposal.
Right.
20. I'm not passing an order. We will just roll over. You make a mention. Because, no, whenever you want, you make a mention. No, I understand, but I'm not passing an order in cases where there is no interim stay, because otherwise there are administrative difficulties. I was earlier doing it, but the registry has expressed some issues because of complaints made. You see, let us say in the board, 20 matters are left out. I'll pass orders in 5 cases, and in 15 cases, there will be no orders. There are complaints coming in because in the 15 orders, there were no cases. How come in item 36 order was passed, in item 35, no order was passed? Correct. No, I understand. You make a mention. You make a mention. We can't avoid, because this is something, wherever jurisdiction court is, you see, today I'm taking this bench. Tomorrow, what I'm taking, I don't know. If I'm taking this bench, you make a mention. No, it's okay. No, it's okay, but there are administrative problems. Because if it's okay, you make a mention. You're permitting you to make a mention, but I'm not passing an order because of administrative problems. If your item is 36, I'm passing an order. In 35, your friend behind your back, he will come and say, why in my case 35 no order was passed, in 36 order was passed. Correct. So I'm facing some administrative problem in passing orders. But interim stays there, we are the. It's okay, but please understand my difficulty. Correct. Make a mention.